Hey guys, good morning, good afternoon, good evening, I think to some of our friends that tune in because it's already 10:30 over here on the East Coast. We are going to be continuing what we're just going to call the What in the Ron Ron saga. So this is ongoing filings, kind of going back and forth between the attorneys at this point in the Emani Ellis v. Cardi B trial. Now, if you've been living under a rock, there was already a verdict in that case. Emani Ellis is filing a motion for a new trial. On Friday, we got together and read Cardi B's response to that. The links to those streams are in the description if you want to go back and replay those. But today we're dealing with the order to show cause saga. So there's been a back and forth with the attorneys. Really, I think the spotlight is on Ron Janfaza, so Emani Ellis's attorney. But anytime he seems to be accused of something, it seems like he makes a counter filing and accuses the attorneys on the other side of something. And today we're going to read his opposition to the order to show cause. So it's 56 pages. There are a bunch of exhibits, though, so I don't think it'll be 56 pages of arguments or whatever we're going to call it. But I already know I agree with Dustin to be good to see you says, I already know it's going to be some foolishness. So I think so too. We are going to get into it. Quick housekeeping. I have pinned the link at the top of the YouTube chat. And then I don't think anything sends over to Twitter. But also on Twitch, you should see a comment in the Twitch chat for today's pinning of the list. So we're going to do a Christmas wish list. Any stream that we do, just for some good old holiday giving. And today it's for a teacher, Mr. Blackwell. He wants to help kids get books for Christmas. So we'll be chipping away at this. If you are so inclined to send a book to one of his students, that'd be cool. These are all things that I'm just finding under the hashtag clear the list over on Twitter. Mostly seems to be school teachers. He said that these are, for the most part, book names that the students are requesting. So, for example, a student may have come along and said specifically, hey, this is the book I want to read, and he added it to this wish list. So that's going to be today's pin the list. Um, we'll chip in towards the end of the stream. I'll send some off before we wrap up. And what better theme than reading and books? We've got 56 pages of Ron Ron to get through. Good morning to FFS as well. Good to see you. Classy Beats in the building. Hey, look, Classy Beats was talking about the DoorDash girl, that whole saga this morning over on his channel. You would think I would need to get away from the crazy and kind of like adrenaline spawning things, but I think we're gonna get back into some crazy as soon as we start reading this. So always good to see you, Classy. You guys make sure you're checking out Classy. He does a morning show, and then also 3 days a week he does a it's really for independent artists. But when I say independent artists, guys, I mean that with all the love. You are going to hear a ton of music that you're going to want to add to your playlist. I think of Classy like the YouTube MC, the YouTube DJ. So make sure you're checking his channel out for both of those things there. Curious Laces, I'm also here for Ron Ron nonsense. Yep. Miss Kel's, good to see you. Trikisha, good to see you. Trikisha's going to be in the bushes. See Mish, and we've got the honorable factual lie in the building. So let me make myself little. Let's get into this. So this was actually filed on the 17th, so on Monday. I didn't see it until late last night. Otherwise, I would have popped live and we would have had some bedtime reading. But we've got the opposition and response to order to show cause, Ron Rosen Janfaza. For trial misconduct, he's going to give us his memorandum of points and authorities. And of course, we're going to get another declaration. Nobody should be surprised that we're going to get another declaration. And remember, this hearing is supposed to be on the 5th. We will also be hearing the motion for a new trial arguments on that day. So, table of contents. I like a nice table of contents. I'm not sure I take too much from this one, though. It's a lot of criticism for the declarations filed by Peter Anderson, Cardi B's attorney. And when I saw this, I could ask myself, what kinds of issues are we taking with the other party's declarations when Ron multiple times now has used declarations as a vehicle for argument rather than a way to put personal knowledge or I have knowledge of because somebody told me this and this is how I got the information, and then rely on what you're putting in the declaration to support an argument in your motion. That's usually how it goes. But we read through several declarations from Ron, and they were just him repeating his argument as if to make it sound truer and more valid. So interesting to see his arguments about why Peter Anderson's declarations are no good. And let's see. We're going to get some cases and let's get into it. So, the order to show cause re Ron Rosen Janfaza for trial misconduct arises out of an assault and battery action where defendant Cardi B was sued by plaintiff Emani Ellis. Defendant assaulted and battered plaintiff on February 24th, 2018. You know, if quick math, guys, that's like 7.5 years ago. And here we are today. The matter proceeded to trial before a jury on August 25th, 2025, and concluded on September 2nd, 2025. Defendant Cardi B prevailed at the jury trial. Cardi B applied to this honorable court by way of her attorneys for the issuance of an order to show cause directing plaintiff's counsel, Ron. He says hereinafter plaintiff's counsel or Ron A. Rosen Janfaza, Esquire. And in the words of Happily Angry Lawyer, just pick one. So we're going to go with Ron. To show cause why he should not be sanctioned and or held in contempt for his alleged trial misconduct. Hereinafter, for the sake of brevity, misconduct. So he's letting us know that he's not going to spell out alleged trial misconduct. But just so you know, anytime he says the word misconduct, he wants you to know that it's only alleged. Included in his purported violations of court orders and the California rules of professional responsibility. It should be noted that there was no prejudice as defendant won the case. And remember, a lot of this order to show cause is happening after like jury deliberations already happened. The parties have always agreed and served all documents via U.S. mail or postal service. Chat, what did we read two streams ago? Maybe it was last stream? I think it was 2 streams ago. Cardi B's attorneys, I should have it right here. Let me just pop it up real quick. And they actually filed a supplement to this now that I think about it. I saw it yesterday. They filed something yesterday, a supplemental declaration regarding their service attempts to properly serve Janfaza, to Ron. Where was it? I mean, we'll just look at it. This is the newer one. Let me pull it up. But we've had these like ongoing Cardi B's attorneys are like, look, we're trying all these ways to serve this guy. We've always been able to serve him by mail, and suddenly there's no receipt. We're unable to reach him at any of these addresses. They're not responding to any of the email addresses at the law firm or the assistants that he directed us throughout the rest of the case to email. And we keep trying to serve this guy, and it's just suddenly he doesn't want to be in receipt of this order to show cause. So they've continued to file these attempts to serve him. So I don't know if I was the judge and I got to this line here in Ron's new motion. The parties have always agreed and served all documents via U.S. mail or personal service. Have we always agreed to that? Because I think there's an issue on your end with that right now. Then courtesy copies were sent via email. Defense counsel served his request for an order to show cause 1 day late on October 3rd, 2025. And we're going to pin that. But presumably, what the argument here is if the jury delivered their verdict on the 2nd, and there was a 30-day window, that would mean the deadline should also be September 2nd. I don't think that that's how that works because I'm pretty sure it has to be when the judgment's actually entered. But we'll see. Let's see what he argues. Defense counsel's proof of service of the OSC documents served states that Miss Myra Izzo of Davis Wright Tremaine, so this is Cardi B, the firm that Peter is from, served the one application of issuance for order to show cause re Ron And two, the declaration of Peter Anderson in support of application for order to show cause run. And three, proposed order to show cause run on October 2nd, 2025. And now we have bold. So bold, underline, that is false. These documents were served via U.S. mail 1 day late on October 3rd, 2025. So he's saying that they're misleading the court, that there was a deadline and that they would have been late on the 3rd. And because they would have been late on the 3rd, according to his argument, I have questions that they intentionally backdated, you know, an affidavit from saying that this was sent out on the 2nd, even though it wasn't postmarked until the 3rd. So let's finish this paragraph and then we're going to look at these exhibits that he's attaching. So this is a fraud on the court as the proof of service was backdated to October 2nd, 2025. The postage stamp in the amount of 10.05 on the right-hand corner of the envelope is dated October 3rd, 2025. And again, we're going to go look at these exhibits. The postage stamp is not from the U.S. Post Office. So it's probably going to be like a prepaid, like someone, when you use a mailing service, you can print, you can have your own stamps, and then it ends up getting postmarked when it's actually picked up by the post office, or accepted by the post office, rather. The postage stamp is generated in the law firm. There you go. The postage stamp is generated in the law firm of Davis Wright Tremaine. So this, in my opinion, helps. Even if there is a deadline for October 2nd, this is helpful. Oh, they're saying that the postage stamp with the date is dated October 3rd. That doesn't make sense to me because the postmark should still only be generated when it's accepted by the post office. And I have not had experience with this in like direct experience in recent years. But I used to, part of the stuff I do for real estate, I used to work for a like lead and marketing company that had a print shop. And for example, all of the proofs for any letters, mailings, we would tell the agents, like, you have to approve the proofs and do this by like, I don't know, like noon, the day that you want them to be taken to the post office, because we need time to print out any pre-approvals and then physically get to the post office. And you'd be able to, like, if we did like prepaid postage, you can print out like indicia, which is like almost like a QR code. It's like a little stamp marking that signifies that this is something that we've prepaid through a business account. But there's other ways to do it where you can have like a metered account and you just have money in there and it deducts. And that's better if you're not doing like standard postcard sizes or things that might be different weights. It can be deducted. You can weigh each packet with the scale that you have at your mailing office. So when that's the case, just because you're trying to print something out from the Postal Service website because you're planning to mail something doesn't mean it's going to be postmarked for that date. So I'm not sure if we're getting that confused here. So then and we're going to look at the exhibits. This honorable court was very clear that the parties had 30 days to request an OSC. The last date to request an OSC was on October 2nd, 2025. I'm not sure about that. I'm not sure if this is an assumption and an argument from Ron, or why we're not just saying the court ordered a deadline of October 2nd. Because it seems like they're looking at a procedural 30 days. But to me, that should go from when the judgment is filed. So unless the verdict was filed the same day, which I don't think it was, and I'll show you the docket, I don't think that 30-day ticker starts when the jury just raises their hand and says we have a verdict. But we'll see. So defendant's request for an OSC was requested 1 day late. Defense counsel was a stickler that the court cannot issue an OSC recontempt for Peter Anderson because the request was 1 day late. Defense counsel should be held accountable. What's good for the goose is good for the gander. The OSC hearing set on December 5th, 2025 at 10 a.m. against Ron should be denied for this reason alone, as defense counsel intentionally and deliberately backdated the proof of service. So let's look down. That he keeps going. There's more about the post service. So let's read this, because if there's more, we'll just look at it all together. There are multiple documents that were served by defense counsel via US mail. The date on the proof of service of each document always matched the postage stamp of the envelope. Defense counsel served many documents to plaintiff's counsel via US mail. Some of the recent documents were served on June 20th, July 31st, August 5th, September 5th, and October 7th. There are many other envelopes as proof if needed. So let's look at some of these. Okay, and then this looks like it goes on to another subject. So if this is a good break point, we'll go look at the exhibits. All right, so this motion is effectively, this looks like an exhibit now. It's like 20 pages of actual motion. So exhibit 1, let's see, this is saying this is the proof of service. And this is, they said Myra Izzo is the one that filed it. And it says, on October 2nd, I served the following documents, the same 3 documents that were listed above, by forwarding a portable document file to the electronic email addresses below. And then it gives Ron's office name and then an email. The same email, you guys remember seeing the Tilly Beverly Hills email a million times in the supplement for Cardi B's attorneys showing that they attempted to serve. Then we also got from an electronic email address, and then it's Myra's email. And then we have also checked is via US mail with a paragraph that says, I place such envelopes with posted thereon, fully prepaid for deposit in the United States mail in accordance with the office practice of Davis Wright Tremaine LLP for collecting and processing correspondence for mailing. So it's not yet accepted. When you're placing this in wherever your mail bin is, your deposit box for your office building, that's not yet accepted by the post office. For example, even if you personally, say it's midnight and you go and drop midnight's probably a bad example. It could be 8 p.m. on November 9th, but the post office is closed. And you go around, you just pull up and you put your letter in the little drop box. You've got your stamp on it. Your stamp is technically prepaid. Right? Your stamp is paid for when you buy a stamp. But it's not going to get postmarked until they collect from that drop box, get it back and sorted, and then accept it. And the date, because they're probably not doing collections at 8 p.m. after the post office is closed, postmark is probably going to say the 20th. But you are placing it and signing all of that prepaid on the 18th. So I'm not sure that I agree that this is misleading. And it goes on, I'm familiar with the office practice of Davis Wright Tremaine for collecting and processing correspondence for mailing with the United States Postal Service, which practices that when correspondence is deposited with the Davis Wright Tremaine LLP, personnel responsible for delivering correspondence to the United States Postal Service, such correspondence is delivered to the U.S. Postal Service that same day in the ordinary course of business. So again, business hours, post office is not open 24 hours a day. So this is like saying within 24 business hours, within 1 to 2 business days, the same day in the ordinary course of business. So let's take a look. So this is the exhibit he's including. He includes the envelope here to show, you can see there's a printed label here with a scannable barcode. And then there's the postage stamp where it actually says the amount and then the date. So this is when we get it postmarked. So then we have it saying October 3rd. He says he includes a bunch of other examples where, hey, we actually said we did this on this date and this date stamped actually matches. Well, I have 2 examples ready. So if we go over to the one at issue, this October 2nd one. When does it say it was received? It's really tiny over here. 6:15 p.m. 6:15 p.m. So that would make sense why whatever mail service that they have at the office building where the law firm's located, or maybe it's outsourced entirely, but wherever they dropped it, this isn't going to get postmarked even though the email is actually sent and Myra did do her side of the work on the 2nd, the individual that collects it, the post office, isn't going to postmark it until the following business day because this is outside the ordinary course of business, 6:15 p.m. An example that he included instead as an alternative, he gave the example of an October 7th filing that was the affidavit was signed as, oh, I sent it by email, electronically, and by US Postal Service on October 7th. And Janfaza's like, well, that one's marked the same, so why isn't the October 2nd one also? They lied when Myra signed it, she lied. She backdated it. This one from the 7th was filed at 7:56 a.m. So the team had the whole day to get something in a mailbox and in an email. I think this is before the start of a business day. If you look at 8 a.m. as the start of business day. So on that reason, I don't really get what we're getting at there. I don't think the 30-day time frame applies. Let's look at the docket. So we've got Janfaza arguing, well, it's 30 days and there was a verdict delivered on September 2nd. Cool. We have notes from the 2nd saying jury trial in progress. And then we have these notices of lodging on the 5th, noticing a proposed judgment. And then on the 16th, we have this minute order. And it's updated a little bit. They make a change to make a correction. Oh, I'm not showing the thing, am I? Okay, hold on. It opened in a new window. Oh my God. Do you guys want to watch me do captchas? Oh no. All right. So we got to find buses, you guys. I think these are buses. I don't know. This one kind of has a bus. Oh no. I'm going to say that one has a bus because there's like a little bus there. I was wrong. All right. Now we got to find boats. I think that's it. We did it. All right. So on September 16th, we have this minute order. And essentially, by adding on the court's own motion, the order to show cause, re-judgment after jury trial is continued. So the court's issuing a continuance. So not only is the verdict, the actual judgment, not accepted into the court docket, onto the record on September 2nd. That is when the jury returns it, but that's not when there's a publishing of it. Additionally, there's a continuance given for the order to show cause. So not only do I think there's a challenge to the naked argument about a 30-day window, but there was also a court continuance. So the whole argument is out the garbage. Secondly, my second issue, with Janfaza bringing this issue forward on the 17th of November. They had hearings about this order to show cause already. He's also responded to this order to show cause previously. And the court has continued. So they had a hearing on the 17th. The issue's over with. Because if you were going to make an issue with this time frame, you should have been making it between the application for the order to show cause, and you should have made it at this hearing. So there's 3 reasons why I think the way we're starting off this response to this order to show cause, this opposition to it, it just reeks of desperation. And I really don't say that lightly. But come on, I'm a layperson. I am not a lawyer. Why am I making considerations for hey, when does the clock for the 30 days actually start? Why am I making considerations for, hey, the verbiage of what Myra is signing off on is that she provided it to her mail service, who will deliver it in the same business day during ordinary course of business, which means business hours. Why am I noticing that there were stays and continuances? So Ron didn't raise an issue with that. Court has moved forward. Court is continuing to schedule a hearing, because remember, the December 5th hearing that's scheduled was initially scheduled for this order to show cause. Ron's got to show up on December 5th. We didn't argue about this He backdated this is fraud on the court until today. What we were busy doing instead, and look at this, guys, I didn't realize this was back to back. Instead of taking issue with someone being late, he's now on the 17th taking issue with the supposedly being late. He filed essentially a counter application for an order to show cause against Cardi B's attorney, Peter Anderson, the very next day. So on October 3rd, he's already filing this order to show cause. Why didn't you raise an issue and just say, hey, even though this application for issuance of an order to show cause is on the docket, registered on the 2nd, and we admit that we're supposed to also accept electronic correspondence by email included, we're going to make the first page and a half of our November opposition scream about how the opposing counsel committed fraud on the court, when clearly this document, it's on the docket, it was electronically served, it was sent by email, and I don't think there's anything that's a misrepresentation in a staff member saying, look, I printed the prepaid information on the 2nd and gave it to our mail office, signed on the 2nd. Like, like this is wild. This is wild. And it's not addressing any of the substantive issues in the order to show cause, in the application for the order to show cause. It's just like, oh, here's a reason why we should have a technicality here. And I just gave you 3 reasons why I don't think this technicality should apply. So, James Phipps says free AI training by CAPTCHA. I like that. I like that. Oh man, CAPTCHAs drive me nuts. Like, they make me feel like I'm crazy and don't know what a boat is or like a car. Sometimes it'll be like, find the traffic lights. And is it only the boxes that include where the light bulbs are? Or is it also like the whole box frame, like the unit and the pole? Like, define this for me. This is vague and ambiguous. I object. So, oh man. Let's get back to, let's see what the next. All right. So, plaintiff's counsel further objects, and I have this real small, sorry, to defense counsel's exhibits 1 through 26 attached to the declaration of Peter Anderson, served on October 3rd, 2025, as the declaration does not specifically state the date and source of each exhibit. The court's docket reflects, isn't it already on the record though? Anyway, we'll see if they need to fix that up. The court docket, and again, this is, it's just another acknowledgement that we're arguing now about, I don't know. I feel like he should have had to have responded by now if we're going back to October 3rd. The court docket reflects that this honorable court issued the order to show cause, rerun, and filed same on October 20th, 2025. Request for judicial notice. The court order dated, so again, so you're acknowledging in this that the court already accepted the application. So this issue to me is moot. It's not timely raised. The court order dated October 20th, 2025 required defense counsel to serve said document via personal service and email no later than November 4th, 2025 at 5 p.m. Guys, this is what we read when we first did a stream on this like a week and a half ago. This is where all of the from Cardi B's attorneys, they are like, hey, we've got an issue here. And even though the court did discuss that they were going to put this out on the 20th, it wasn't actually, we were not in receipt of it until the 27th. So when you have to serve something that the court produces, you need to use that proper filing, the official filing. You can't just go write up like something on a post-it and give it to somebody and say, hey, this is just me relaying the thing I'm supposed to serve you with. you've got to get the official packet from the court. We looked at that memo in relation to this October 20th. So let's flip over. Let's look at that summary here. So again, this is from Peter Rosen. This is from Cardi B's attorneys. Um, why am I switching their last name? Rosen is the other attorney's last name. Peter Anderson. So on October 20th, the court granted the application of Cardi B, professionally known as Cardi B, for an order directing Ron Ron to show cause, why he should not be sanctioned for trial misconduct. While the court's order to show cause bears the October 20th filed stamp, it was not provided to the certified electronic service provider, One Legal, and in turn provided to defense counsel until 5:08 p.m. on October 27th, 2025. And they attached this all below as exhibits. Nevertheless, defendant promptly sought to personally serve Mr. Rosen Janfaza with a copy of the order to show cause and application papers. And then they detail why they believe Janfaza has willfully evaded personal service. So this has already been addressed, this time frame. And it seems like what we're about to read here from Ron Ron is just going to ignore the context given and possibly hint that he was knowingly evading what he knew would be service. So the court order, we're back to Ron Ron's filing. The court order dated October 20th, 2025, required defense counsel to serve said document via personal service and email no later than November 4th, 2025 at 5 p.m., which was never accomplished. Defense counsel concedes that he never served Ron Rosen Janfaza, Esquire. Defendant Cardi B's application, and I have another point, but we're going to finish reading this before we do the what? But defendant Cardi B's order to show cause application is predicated on an order to show cause issued by this court on October 20th, 2025. So again, what are we arguing the October 3rd mess for? The court granted defendant's application and pursuant to Code of Civil Procedures 1775, 1209A5, 1211A, and 1218, and the California Rules of Professional Conduct 3.4F, and all of this other stuff, as more fully discussed below, these rules have no application in this matter. The issuance of an order to show cause was deemed appropriate because defendant Cardi B argued the record established the court's, quote, firsthand. Okay, this is going to get into another issue. So let's jump over to the docket real quick. Because the point I want to make before we go too far is we're taking issue here. The court order dated, it had to have been served no later than November 4th at 5 p.m. Do you guys remember what's happened since? Do you guys remember what's happened since we read the supplement from Cardi B's team saying like, hey, we've made all these attempts to serve this guy? Well, there was a hearing. Now we're going to look at the minute order. As soon as I do, we got the traffic lights. I brought it upon myself, guys. Right, is that all of them? I don't know. Maybe there's some in this one. Oh, there's someone in this. Wait, I checked that one already. Is that a traffic light? That looks like a traffic light, or is that a mirror? Oh, I'm going to get this wrong. I don't know. Oh my God. Buses, plural. No, chat. Oh no. Okay. Like, do these not count? Should I not click like this one that has a piece of the motorcycle? They're going to lock me out. There's a little handlebar here. That one worked. That one worked. Yeah, we're back to the Cardi case. So let's look at what happened in between. So defense made their arguments like, hey, we're requesting relief. We are asking that you deem Ron Ron officially served. And in case you don't want to deem him served, that you permit us to exercise alternative service. Because here's all the attempts that we've made. And at this point, it seems like he's evading service. Well, on November 6th, so everything that Ron Ron's arguing about and what we were just reading is arguing about, well, they should have tried by the 4th. Their deadline passed. He's ignoring that there was a procedure followed. We failed to successfully serve him. We're requesting relief from the court to deem him served on these grounds. And then on the 6th, the court made findings. The court made a ruling. So, nature of proceedings. Well, wait. Appearances. What does this say up here, guys? This hearing, nobody was present for the plaintiff. No appearances for the plaintiff. That's Emani Ellis. That would be Ron Janfaza. Ron is Emani Ellis's attorney. Ron is Ron Rosen Janfaza. Aaron says good morning to everyone but Ron. Slim Life NJ, thank you for the reminder. Hit that like button, you guys. Let's get those numbers up. Um, I realize a lot of people, I saw it in the stats. It's really cool. A lot of people watch this on TV. Like half of my audience watches this on their TV. And I don't know if you guys like pull up the chat on your phone. Um, but I tried to like the chat is different when you're looking at your TV. And I don't even know if you can hit a like button over there. So if you guys are on your phone or on your PC and it's easy for you to hit the like button, could you hit the like button? Because I think it's a bit more difficult for half of our viewers here to hit that like. But yeah, so we have no appearances here. So are we just pretending like we're reading through this and we're getting all of this? We're acting like we're responding to the opposing party in this motion, this filing from the 17th, from Monday. But you're not really, the issue is no longer with the opposing party because the judge has made rulings. So now your issue would really be a request for reconsideration. This is not the appropriate way to be arguing this. You're disputing a service issue when at a hearing that you were not present for, you failed to appear, a ruling was made. You need to seek reconsideration for this. This does not belong in your opposition to the order to show cause. So, but again, I'm not a lawyer. I'm not a lawyer. Not a lawyer. So this minute order from the 6th of November, hearing on ex parte application for order reservice of order to show cause on Ron A. Rosen Janfaza, memo of points and authorities. The matter is called for hearing. The court notes that there are no appearances by or for plaintiff's side, nor communication with the court as to why there are no appearances by counsel or parties this date. The court and counsel confer regarding the status of the case. After hearing from parties, the court will deem served. So the court made a ruling. We're going to deem Ron Rosen Janfaza served and will modify the proposed order. Defense is directed to overnight deliveries with a request for signature or email if available. And I believe they filed like a FedEx. Do I still have it open? If it's open, we can just take a peek. Yeah. So look, ship date 11/6. They FedEx priority overnight. This just after this minute hearing, they set this up with a FedEx priority overnight, and it's noted that it was refused by the recipient. so, so what are we doing? What are we doing? So that again was the minute order. We have this overnight delivery with FedEx made like they got out of the courtroom and got it going. Because when does it get picked up? There you go. So a whole mess. Like, is this really what somebody is billing? I mean, again, maybe he's not billing Emani Ellis. Maybe it is all contingency, but I would be damned personally. I would feel offended on someone else's behalf if they were getting charged billable hours for this mess. So let's get back to the argument. So again, in this November 17th filing from Monday, Ron is, oh, he was supposed to serve us by the 4th, and defense counsel concedes that he never served me. Yeah, we had an entire ex parte application to deem you served, and the judge ruled he's served. And then we have, when he's supposed to, the opposing counsel is supposed to serve that to you, we have FedEx noting that you refuse service. Refuse delivery. So he's really arguing here, haha, defense said that they were not able to successfully serve me, in the same motion where he's arguing the parties have always agreed and served all documents via U.S. mail or personal service, and courtesy copies were sent via email. You can't have this both ways. Like, why would you write this to a judge that I'm sure you're already on thin ice with? Why would you do this? Just crazy. So where were we? We were down here somewhere. So yeah, defense counsel conceded that they couldn't serve me. Yeah, and the court said, "Okay, I deem him served." Hello. Hello. Yeah, this is just like, "Oh, Ron. He's ridiculous." Mrs. K. Griff, good to see you, says, "Oh, Ron. Good to see you." I think we're gonna have a lot of "Oh, Rons" here. Ah, Lakia says, "When I watch on my TV, I go to my phone to like." I also notice, and I'm gonna change how I do like trial watches, but I noticed, like, you see where I am on the screen right now, and I guess you're probably blocked if you're watching on a TV and have the comments up. Um, and I would advise other creators as well. If I were to put this up and leave it over here, this is kind of where the comments show on the TV. At least through, like, the YouTube how the YouTube application, I don't know what operating system my TV is, but whatever it is, it pulls up the comments on the side, but they're, like, individual, and it'll show, like, 3 at a time, but they'll take up the entire, like, right third of the screen, and they're transparent like this, they don't fully cover everything, um, but, like, I wanna set something up where, like, when I have a screen like this, maybe I can flip it so my picture's hidden behind the comments, for those that are watching on TV, and the document or the screen or whatever's actually important that we're looking at is on the first 2/3 of the screen on the left. So I'm going to play around with that and make it better for TV watchers. I never really paid attention to the format that that displays in. So thanks for the feedback, guys, in the chat. Um, and I'll play around with my layouts there. See what we can do. Again, especially when we're watching a trial, I don't want to cover the closed captions. I'm sure some of the time when I move them to like the right corner of the screen, they've got to be getting blocked by the TV chat display. And that's like 49% of people that view these trial watch streams with us. So so we've got, what do we got next? How does it keep going? So defendant Cardi B's order to show cause application is predicated on an order to show cause issued by this court. Okay, we started to read this, but let's read it again. That was October 20th, 2025, which is why we're taking, it's weird to be taking issue with someone maybe being a day late. And I think I have 3 reasons why it's arguably not late. That October 2nd and October 3rd thing. You could have raised the issue then if you had time to file a counter petition for an order to show cause. So the court grants that application. The issuance of the order to show cause was deemed appropriate because defendant Cardi B argued the record established the court's firsthand observation of. So direct. Ron A. Rosen Janfaza. And this is the way Ron is wording this. I disagree with the characterization that this is the only reason and the only issue that an order to show cause was issued for. Because there were parts where Cardi B's attorneys would say, as the court themselves noted, for some of the aspects. But a lot of the other issues raised were things that happened outside of court, outside a court proceeding. And it would be like, hey, actually, Ron Janfaza sent this email saying he'd go to the press if we don't agree to settle. Well, that obviously wouldn't be within the court's firsthand observation. So there was like a mixed bag included in that application. So to characterize it now as if that's the only argument that Cardi B made, that's not accurate. But yeah, so they're saying that this was deemed appropriate because it was the court's firsthand observation of Ron's willful disobedience of lawful court orders and improper advocacy, despite the court's express admonitions to him, which willful disobedience and improper advocacy threatened to undermine the integrity of the proceedings. The order to show cause was based upon the application of defendant Cardi B and her attached memorandum, accompanying declaration of Peter Anderson, the reporter's transcripts of the proceedings on August 25th, 2025. And again, anything that's really in the transcript of the proceedings, unless it also involves a additional context that happens outside the courtroom, if it's on the record, it's going to, be direct knowledge of the court. through and including, or in chambers even, through and including September 2nd, 2025, and the records and files in this action. So, what's the issue? So, Code of Civil Procedure 473B provides the court may, upon any terms as may be just relieve a party from a judgment, dismissal, order, or other proceeding taken against him or her through his or her mistake, inadvertence, surprise, or underlined excusable neglect. The accompanying declaration of, and we're going to get a declaration. The accompanying declaration of Ron A. Rosen Janfaza reflects that the errors were due to said attorney's mistake, inadvertence, surprise, and or excusable neglect. So why didn't we underline this whole thing? So we're going to have a declaration. This is basically arguing, like, we're getting to, hey, court, you could, if you want to, relieve me from this order to show cause proceeding. You could just decide to not do it at all. That's what this is arguing. And the reason we're going to ask for that is I accompany this with my own declaration saying that the errors were due to mistake, inadvertent, surprise, and or excusable neglect. Why didn't we just underline all of these up here? The aforementioned errors during the trial were due. So I guess this is conceding, right? Ron argued above that defense conceded that they were unsuccessful in attempts to serve him. Is this not then a concession that, hey, I did make these errors and I did make these mistakes? The aforementioned errors during the trial were due to plaintiff's counsel mistake, inadvertent, surprise, and or excusable neglect for the reasons stated herein. And now we're getting into procedural background. So whenever they cite the declaration, like more officially, we can go down and read that. I bet that's going to be just repetition of whatever arguments are laid out. So oh, I love the movie Matilda. Matilda is like such like a wild time capsule to go back and watch now. Um, but yeah, Mrs. K. Griff says Ron reminds me of Matilda's dad, slimy and dishonest, used car salesman vibes. So there you go. Just crazy. Jeremy says, so question for this Ron. Did Hamburger University have a law school division or is he just an idiot? I don't know. Maybe like check if he's all right. Maybe gotta check if he's all right or just like on the edge of losing it. Oh, Aaron, so this isn't a response to the court's order. It's worse. This is a opposition in response to the order, the application by Cardi B's team for an order to show cause. But he's including, well, I don't even know if I would call it including a response to the court's order because he's sidestepping it and ignoring it. And it's almost like he thinks that because he didn't make an appearance, that he shouldn't be aware of the minute order that's on the record that notes that the court's confused why no one made an appearance for plaintiff and that an order, the court ruled, you're served, you are deemed served. So it's like he's still living in this la la land where if I didn't show up and I didn't hear about it, I don't know about it. It doesn't work like that. You should have known about the proceeding. You're probably going to have to explain why you didn't show up. Like the judge might just layer that on this December 5th order to show cause hearing and ask, and where were you on November 6th? But you still should have seen the minute order. There's no reason you shouldn't have seen the minute order. So, and again, we saw the FedEx thing where when Cardi B's team tried to send over the order saying like, hey, we had this meeting and judge rules that you've been served, he refused the delivery. So none of this looks good. None of this looks good for Ron. So I don't know. Oh, just a hot mess. Not a toddler hiding their broccoli. Ah, man, that's hilarious. So we've got, are we going back to this? So on October 20th, 2025, the court ruled Cardi B, having presented to this court sufficient grounds to initiate a contempt proceeding to show cause. This is going to be addressing the court again. All right. I think he's just doing a blended argument. He's going to say that the order to show cause, like some of this stuff he should have included before the October 20th decision. And he didn't do it, even though he's now arguing that the other party was late on October 2nd. So I don't know. I think if he was able to, he would just scream at the judge and the opposing counsel if they could both be in the same room together. But unfortunately, he does not seem to make appearances. Defendant Cardi B, having presented to this court sufficient grounds to initiate a contempt proceeding to show cause that Janfaza should not be, one, held in contempt or otherwise sanctioned, both for ruling this court's July 30th, 2025 order precluding evidence or reference to purported gang affiliation and excluding Dr. Alex Avila as a witness, two, held in contempt or otherwise sanctioned for both, and this is bolded, for violating the court's September 2nd, 2025 order in open court not to reference in his closing argument facts not in evidence, and three, held in contempt or otherwise sanctioned, or both, for trial misconduct, including his closing argument. I wonder why these are bolded and this one's not. Because I'm sure he's going to argue that this is should be direct contempt because it was within the court's observation. But technically, this is two because the violation of the court's order would have been this reference to purported gang affiliation that I think happened during closing arguments. But whatever it was on the record. And the exclusion of a witness would be court's order also on the record. And then you violate it. So by mentioning it. So I don't know why these two are underlined. The court incorporated by reference the October 2nd, 2025 declaration of Peter Anderson, which in parentheses not served until October 3rd, 2025 via U.S. mail, and attached exhibits as the affidavit of facts constituting contempt for purposes of Code of Civil Procedure, Section 1211A. Identified counts of Ron is charged with. So Ron was ordered to show cause as to why he should not be found in indirect contempt. This is based on the court's decision to treat the declaration of Peter Anderson and its attached exhibits as an affidavit of facts supporting contempt in accordance with the Code of Civil Procedure 1211A. And he's doing this weird thing where the underlines are extending too far. That's not a hanging one, but there was one further up where the underline went too far. We're missing a bolding on the first letter of words. We're trying. All right, so now we're going to look at 1211A. So Code of Civil Procedure 1211A provides in part that when a contempt is committed in the immediate view and presence of the court, so this is direct, this would be direct, it may be punished summarily, for which an order must be made, reciting the facts as occurring in such immediate view and presence, adjudging that the person proceeded against is thereby guilty of a contempt, and that he or she be punished as therein prescribed. When the contempt is not committed in the immediate view and presence of the court, an affidavit shall be presented to the court of the facts constituting the contempt. As more fully discussed below, the court does not have the authority or jurisdiction to find Ron indirect contempt, as the alleged 25 counts of contempt were allegedly, in contempts in quotes, were allegedly committed in the immediate view of the court, and Ron A. Rosen Janfaza conduct and actions as a matter of law do not constitute indirect contempt in accordance with 1211A. In her moving papers, and this 25 counts, I'd have to go back and look, but I thought it was a hybrid of issues where some did happen within the courtroom, most happened within the courtroom, like issues with things being mentioned during closing arguments that shouldn't have been, that weren't permissible anymore. But yeah. In her moving papers, defendant Ella Manzar concedes the court's firsthand observation of, we have the hanging underline here, Ron A. Rosen Janfaza's willful disobedience of lawful court orders and improper advocacy. The court does not have jurisdiction to hold Rosen, we're just going to say Ron. Rosen A. Rosen. No wonder I got confused. Now we're going to have to say Rosen instead of Ron. The court does not have jurisdiction to hold Rosen A. Rosen Janfaza in contempt or issue sanctions, as his alleged contempt must be treated as direct contempt. According to In re Hallinan from 1969, Direct contempt occurring in the court's presence can only be punished summarily by the court based on its own knowledge. Ron A. Rose and Janfaza's contemptuous acts are admitted to having occurred in the court's presence. The 25 counts of contempt consist of the following acts as noted below. Okay, so we're jumping into a new section, but it looks like we're going to go through the counts. So first we have a bigger header labeled as 3, section 3, improper examination of witnesses. The following are specific examples cited by Peter Anderson in support of the affidavit of the facts constituting the contempt counts 1 and 2, which were made in the immediate view and presence of the court. So count 1 would be inquiry into gang affiliation. So again, this is going to be on the record because this was happening during closing arguments. And the issue was that Ron, or Rosen, improperly questioned a witness regarding gang affiliation, despite a granted motion in limine that explicitly precluded any reference to, argument about, or introduction of evidence concerning any former gang associations or affiliations during the plaintiff's youth. And they cite the declaration of Peter Anderson. And then we also get a counter to it. So not only are we arguing that it's the wrong type of contempt, but we're also arguing, substantively, saying, well, this was done in error by plaintiff's counsel who has taken responsibility for said mistake. And also this is wrong because this should say defendant's youth. So, but okay. Then 2, they talk about count 2, submission of unauthorized witness list. Ron unilaterally submitted a purported joint witness list to the court without endorsement from defense counsel. And it would be helpful if he formatted this, when you're quoting the argument from Cardi B, it would be helpful if he quoted it, especially to distinguish it from the argument he makes following, right? This should all be in quotes. So Ron unilaterally submitted a purported joint witness list to the court without endorsement from defense counsel. This list included Dr. Avila as a witness, even though the court's July 30th, 2025 order in response to motion limine number 3 had precluded Ron from calling Dr. Avila. The motion limine had struck Dr. Avila from the plaintiff's untimely expert list and declaration and precluded his testimony at trial. Supporting evidence can be found in the declaration. And so, this, if this is an actual quote, this is read like it's supposed to be a quote, but it's not in quotations. So who knows if it's actually word for word. Because up here, this plaintiff mistake, maybe that was included in the original, in Peter Anderson's filing. But this is representing an argument from Anderson's filings, from Cardi B's side. And then it shifts right here. The next line shifts into an argument about what should be in quotes. It goes on to say, however, the court did state that Dr. Avila could be called as a rebuttal witness. The contempt, if any, was made in presence of the court. So this is just bad structured writing. But maybe we just didn't want to be responsible enough to quote something in whole. So we just said, we'll just write it without quotes in case we make mistakes. The next thing is counts 3 through 9, repeated improper questions about Dr. Avila and psychological records. And now we're back to writing in the third person. We're not quoting. We're saying that Ron is alleged to have improperly questioned witnesses regarding treatment by or medical records from plaintiff's treating doctor, Dr. Alex Avila, and other psychologists in direct violation of the court's granted motion in limine 3, which excluded such evidence. And then we get in bold. The following are specific examples cited by Peter Anderson in support of the affidavit of the facts constituting the contempt made in the immediate view of the presence of the court. So we've got asking the witness, and this is not bolded anymore, asking the witness if the witness received treatment from Avila and other psychologists between October 8th, 2022 and July 2nd, 2023. Bolded then, the objection was overruled and does not support the charge of contempt. So, again, I think this is just confusing. We give the example and then we're highlighting our arguments in bold. And we say here we cite Exhibit 3, And then when we excite Exhibit 5, we say, please see Exhibit 5. So they really want us to see that exhibit. Inquiring about treatment from Dr. Avila and other psychologists during that time frame, the objection was overruled and does not support the charge of contempt. Questioning if the witness reviewed any of Dr. Avila's medical records for psychological treatment. Asking if the witness reviewed psychological records from Premier Forensic Psychology and Dr. Avila. Referencing medical records from Dr. Avila, among other things, in formulating opinions and stating that the plaintiff received 12 treatments at Dr. Avila's office. This one also has the objection was overruled. And I think the argument from Peter was, here's all these examples. They kept doing it. They kept doing it. So even if you overruled some of them, it's still a cumulative, like cumulatively, it's an issue. And then another example. So I guess these ones they weren't objected to, or if it was, maybe it was sustained. Next, we have another section, but we're still dealing with counts. So improper closing argument conduct. I wonder if he just like copied and pasted this part of the document and then like deleted and then started writing what he wanted to in the areas where he deleted. Because he's copying the headers, but they're being placed in here as if they're headers for his filing rather than being like a quote within a filing. So let's see how he argues count 10, the reference to Dr. Avila in closing arguments. During closing arguments, Ron improperly referenced plaintiff's visits to Dr. Avila in violation of the motion in limine and the court's orders. The alleged contemptuous conduct occurred in the immediate view and presence of the court. All right, so this is just saying that it's direct, not indirect. I think same argument for counts 11 through 25. The issue is that it's direct, not indirect. More of the objection was overruled. Objection was overruled. Objection was overruled. And a bunch of other blank examples. No counter argument to the other examples. So yeah, I don't really see the purpose of this if we're going to leave. Like, sure, you have a counterpoint that you're offering to some of the examples, but it's only a few of them. There are way more examples that you're not giving an argument, you're not making an opposition to. So it seems like an incomplete opposition. Let's see. Next section. So again, he's using these sections. This is back to a section that's like part of his own writing. Like this header is not part of Peter Anderson's application and arguments. This header makes sense for Ron's arguments. So we're back to just Ron making arguments now. That the purported contemptuous acts from Ron, if true, constitute direct contempt, not indirect contempt. A contempt committed in the immediate view and presence of the court or the judge in chambers constitutes direct contempt and may be treated summarily. When contempt is committed in the court's immediate view and presence, it is termed direct contempt and may be treated summarily. No affidavit or order to show cause is required. All that is needed is that an order be made reciting the facts, the person adjudged guilty, and the punishment prescribed. In a contempt proceeding, the evidence, findings, and the judgment are all to be strictly construed in favor of the accused. So now this part is true, you know. You have to read, it's a higher burden to make a finding of contempt. If the record of the proceedings reviewed in the light of the foregoing rules fails to show upon its face the existence of all the necessary facts upon which jurisdiction depended, the order must be annulled. But okay, I don't get this argument because you just recited a bunch of examples and you left a lot of them uncountered. So I don't think you've successfully made this argument that the record of the proceedings fails to show the existence on its face, a facial showing, the existence of necessary facts. You recited them and you didn't challenge them. Any contempt order made concerning matters not occurring in the court's presence is invalid if it's not supported by a proper initiating affidavit. A judge may defer the adjudication of contempt and the imposition of punishment. And I was going to say, there's discretion here. So with direct contempt, the judge can say right away, I'm going to find you in contempt. Here's why. Or I need a couple minutes and I can come back. I can go to my chambers for a few minutes, come back. I think there was like an infamous moment where Paige Whitaker did that in the YSL trial. She said she needed like 10 minutes and she came back. But you can come back and say right there, I'm going to find you in contempt. But you can also say, I'm going to schedule a hearing. So Ron, after several paragraphs, several pages, is acknowledging that a judge may defer the adjudication of contempt and the imposition of punishment until the conclusion of a trial. However, where final and decisive action is deferred until a trial is concluded, an adjudication of contempt and sentencing without affording the accused contempt notice or an opportunity to be heard may be violative of due process. Proper notice is required. So his argument, it's direct contempt, it's direct contempt, as if he wanted to argue that it's direct contempt, so you must have told me right then and there. We shouldn't be initiating this after the fact. Oh, oops, actually you can. But nobody served me. Nobody put me on notice. I had no chance to speak my piece. Well, you didn't show up for a court appearance. You missed it. Not only did you have opportunity to respond, you can look at the docket. You were electronically served, and now you're raising an issue about a 1 day late, possibly, mailing service back in the beginning of October, even though it's on the docket for the same day. And you filed your own application for an issuance of an order to show cause in the opposite direction the very next day. So this is him just plugging his ears and acting like, if I can just pretend that I'm not aware of any of this stuff and I don't show up for court appearances, not even for myself, but also on behalf of my client, I can just say, I don't have notice. You were deemed served. This is crazy. This is crazy. Oh my God, this is crazy. Guys, a valid contempt order must be issued addressing the court's jurisdiction, knowledge of the order, ability to obey the order, and a willful disobedience of the order. Defendant's order to show cause failed to comport with the established due process principles. Therefore, the instant OSC must be denied. Counts 1 through 25 stem from actions that occurred directly in the court's presence. The OSC relies entirely on Code of Civil Procedure 1211A, which pertains to indirect contempt. Didn't he say that he said earlier that it relied on several sections of different areas of the code. But now it just relates to 1211A, so I don't know. Since all acts occurred before the court does not have jurisdiction to hear the defendant. Indirect contempt proceedings may only address actions not committed in the immediate view and presence of the court and must be initiated by an affidavit describing the facts of the alleged contempt. Defendant Almanzar concedes that all of Ron Rosen Janfaza's contemptuous act, no plural, were committed in the court's presence. All right, now we're getting to the issues of the declaration. And I don't know, maybe we should look at the actual order to show cause. What is it? Let me pull that, because that one, I've been relying on the preview pages, but I have to actually buy this one because this one's more than one page. So give me a second to let that go through. And we'll look at what was issued on the 20th. I have to do some captchas. Please select all matching images. What? Can't serve him if you can't catch him. Oh my goodness. Can we just view this here without me downloading it? That would be great. Okay, so this is the order from October 20th. To Plaintiff's Counsel, Ron Janfaza, defendant Cardi B having presented to this court sufficient grounds to initiate a contempt proceeding, you're ordered to appear on December 5th, 2025 at 10 a.m. in Department T of this court, located at 150 W. I can't hear the word Commonwealth. All I think of is Karen Reed in Alhambra, California, to show cause why you should not be held in contempt and all of those things. Um, yeah, so I don't know. I mean, the judge is acknowledging that some of it happened in open court. The court incorporates by reference the attached October 2nd, 2025 declaration of Peter Anderson, the thing that was served late, apparently, and exhibits as the affidavit of facts constituting contempt for purposes of Code of Civil Procedure, Section 1211A. Okay, so we are only getting 1211A here, but it's only for what the court's incorporating. Here, we have additional issues: violations of Code of Civil Procedure and Code of Professional Conduct. So it looks like Ron Rosen is acting like the only thing cited was the Code of Civil Procedure 1211A. And looking at this order, that does not actually seem to be the case. It is further ordered that this order to show cause, together with the application and its memorandum of points and authorities, and the declaration of Peter Anderson. This is where we get that November 4th thing, where the Peter Anderson and his team have said, look, we've tried. We've reached the magician. We've gone to the building. We heard that there was an issue with the janitor dealing with service of or another litigation matter, where I think a janitor working in the building where Janfaza has his mail addressed. There was like some car accident that the janitor was going through, and he had some agreement to retain Janfaza as an attorney, and it seems like Janfaza wasn't doing the work, and it became a whole dispute. And Ron is not supposed to physically be in that building anymore because of a previous physical altercation with the janitor. I know that sounds crazy because it is crazy, but something to that effect. Um, but yeah, that's why there's like all these issues to service, but the court permitted service to the email Tilly Beverly Hills. And we've heard what happened since. On the 6th, the court deemed Ron Janfaza served. Proof of such service shall be filed at least 26 court days prior to the hearing. So they did that well before that. And it doesn't matter because the court's deemed him served. Any opposition papers to the order to show cause shall be filed and served on counsel for Miss Cardi B by email in first class and no later than 11/17. So I just actually, now that I'm seeing that, 11/17 was the deadline here for, we were on page 13. So we had an issue because like this is technically after close of court, what Ron filed this week. So this whole argument about lateness, you just swung the door open for them to argue that this is late. And there is no 30-day window here where we're guessing the math. This is outlined specifically as November 17th was the deadline, not there's 30 days. And I, Ron Janfaza, am calculating 30 days from what I'm deciding is the proper start time of September 2nd and deciding that October 2nd was the deadline. Oh man, what are we doing? I don't know if there's anything else in this order we want to read. Any reply papers to the opposition shall be filed and served on. So we'll get a response by what is the 26th, next Wednesday. So plan to get together for more what in the Ron when we have some responses from Cardi B's team in the next week. Maybe next Wednesday we'll get back together same day, same time. And let's see. These proceedings, to the extent premised on a charge of contempt, are quasi-criminal. And to that extent, Ron Janfaza has the rights described in Code of Civil Procedure, Section 1217. On a finding of contempt, the court may impose, per count, penalties under Code of Civil Procedure 1218A. And then we also have 1222. And then there you go. There's a judge's signature. So I don't know. I just honestly feel lost. If we go back over to Ron's filing, we just have eh, it's like he's ignoring any other statute that's cited. And it's just saying 1211A. So uh, I think we were down here. Yeah, so we were down here on section 6. This is a trip, you guys. So let's see. Now we're going to get into these declarations and why the declarations of Peter Anderson lack the required specificity necessary to establish a jurisdictional foundation for the court to determine indirect contempt. Even if Ron's contemptuous acts were deemed to constitute indirect contempt, which they are not, the declaration/affidavit of I didn't read that order, and again, I'm not an attorney, but I did not read that order as putting things into a box. It was the court saying that they took into consideration the arguments raised by Peter Anderson and his team. So, but okay. Let's see what he argues about. Again, we're arguing 1211A only, which requires that an affidavit supporting a contempt proceeding must set forth the specific facts constituting the alleged contempt with sufficient particularity to apprise the accused of the nature of the charge and to enable the court to determine whether a prima facie case exists. The declaration of Peter Anderson fails to articulate the essential factual elements of contempt, and therefore, the court lacks jurisdiction to proceed with the instant order to show cause re-contempt. The affidavit of Peter Anderson, Esquire, constitutes the complaint. The affidavit, the OSC, the evidence, we have a unbolded A, an unitalicized A, and then we go back to full emphasis, are to be strictly construed in favor of the accused, and the presumption in favor of the regularity of the proceedings and the judgment does not apply in contempt matters. The accused is entitled to be clearly and fairly apprised of the particular accusation against him. For over 100 years, it has been well established in California that a contempt, being a criminal proceeding, requires that a party is entitled to know what he is charged with. It will not be presumed that he was held guilty of some act not specifically alleged in the affidavit or fairly covered thereby. The offense being criminal in its nature, both the charge and the finding and the judgment of the court thereon are to be strictly construed in favor of an accused. We're going all the way back. Yes, this is 100 years and change to 1896. The affidavit by which a contempt proceeding is instituted in order to sufficiently support an adjudication of contempt must state facts constituting the offense. Otherwise, the court is without jurisdiction. Does he think that the court can't hear? And who hears a matter of indirect contempt if not the court? Maybe I'm missing the argument. Like, is he just simply arguing that the vehicle shouldn't be a show cause hearing? Even though he acknowledged previously that the court can wait until after a trial's done and schedule an order to show cause hearing? Or is he just getting lost with like the term jurisdiction? And thinking that if it's not indirect, there can be the court can't order him to show cause. No intendments or presumptions can be indulged in aid of the sufficiency of the proceedings. You just argued that all of his examples are on the trial record. You did that to argue that everything is within the court's knowledge. So if the examples cite to, said this thing, I don't know if there's a lack of sufficiency, especially if you've already responded to them. So he had filed certain arguments responding to some of them. Presumably, if you're responding, you're aware of what you're addressing, but maybe not. It is immaterial as it affects the sufficiency of the affidavit and what facts are proved or found by the court. The accused is entitled to be clearly and fairly apprised of the particular accusation against him All elements of charge contempt must be averred in affidavit of the accuser and must be developed in the proofs. A finding that one accused of contempt is in violation of an order of court states only a conclusion of law. And then we go into another issue of the declaration. So the declaration of Peter Anderson and supporting exhibits 1 through 10 do not support Ron A. Rosen Janfaza violated any in limine orders. Only precise court orders. I mean, those affidavits from Peter were like, court issued a motion in limine number 3, and it said the specific motion in limine and the order. The court granted that one. And then Janfaza did this thing in violation of that thing. Like or is he saying that because it wasn't in a declaration and it was only in a motion? So because he didn't repeat the arguments from the motion in a declaration, the court shouldn't consider it? We have a fundamental lack of understanding on the purpose of declarations. Oh my gosh. Before we get into this, let's hop over to the chat. Hey to Idiot Wind, good to see you. I saw Jeremy here saying, thanks to Wind, I was really lost. So I looked up, I see you in the building, good to see you. This one I think is a headache starter. Yeah, Aaron, I'm not crazy, right? Like, it was pretty specific. It was like, I'm remembering like specific pointing to motion in limine number 3, and then he did this anyway. So I don't know. I don't know. Betsy's like, how does this guy still have a law license? I don't know. He was concerned that he was apparently being threatened with someone reporting him to the bar, which we've seen the counter arguments to that, but yeah. Oh wait. Does he So we didn't continue, but I'm looking at the screen. The specific motion in limine is cited in the thing he's going to talk about. What is he doing? Oh my gosh. Hey to Kitty Cat, good to see you. Hope you're doing well. Yeah, Mrs. K. Griff says he beats up lawyers and janitors. Was a janitor wearing glasses seems to be a trigger. Yeah, so and Miss Griff, I don't know if you know GV. GV's around, like, I think a lot of the same chats. I see GV all over YouTube. But GV had to relay to me the glasses story and the mistrial. Like, what are we doing? What are we doing? Like, this is not a work from home job, but maybe it should be for people that can't keep their hands to themselves. Aaron says, Your Honor, the magician hacked my e-file account. Yeah, don't use the Tilly Beverly Hills email anymore. The magician hacked it. Hey, KP, good to see you. You got Amy E back in the building. Amy, this is this is a time. This is a hot mess. Thanks for hanging out with us. Good to see you. You guys, as usual, make sure you check out Amy E. I think Keisha described Amy E's channel as having all the crazy. And that is a good way to describe it. I think that was the word Keisha used. It is a bunch of very exciting body cam footage, and usually premiered, so there's a live chat feature where you can talk about what's going on. But make sure you're checking Amy E out. I think, yeah, it was Keisha. I think she said it was all the crazy over there, but aptly described. Hey, Christine, good to see you. Oh, no. Ugh, no. I hope he doesn't go into, like, elder law. Moving on to nursing home residents. No, 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 no. This is crazy. Yeah, and Betsy, like, this whole filing seems to be a ride to an argument over here, and then the next paragraph is a counter to that argument. Like, I don't know. Like, did we write it like this and not even think? Like, when passions are high, sometimes, like, your words move faster than your mind can keep up with. Like, I don't know what we were doing. I don't know. I don't know. Oh, crash outs. Trickies just says it was crash outs. Yeah, so all the crash outs are on Amy E's channel. Love Amy E is the channel handle. Let me get the link real quick. Although, Amy, I'm noticing if I search your name, I'm starting to actually see your content pull up. Like, you're getting into the search algorithm. And it's less Amy Lee, the singer from Evanescence. So it's where it would always try to steer me if I typed to find your channel. But yeah, guys, so link is in the chat for Amy's channel. If you're looking for her after, search for Love Amy E, like all one word, no spaces to find her proper channel name. But you're getting into the algorithm finally. You're beating Amy Lee from Evanescence. So let's see. We're going to see that this declaration, we just heard it wasn't specific enough. But now we're going to hear another argument that the declaration to Peter Anderson and supporting exhibits 1 through 10 do not support Ron A. Rose and Janfaza violated any in limine orders. Only, and what is he? Is he like not highlighting some things to show that he's not using AI or something? Like, this is like the fifth time that I've noticed we have like a hanging emphasized or not emphasized letter. Only precise court orders as written may be enforced by contempt. In Ray Marcus 2006 case, okay, that's where they're getting that from. The declaration to Peter Anderson filed in support of issuance of order to show cause that Ron Janfaza violated the court's in limine order 1, motion in limine 1, the specific motion in limine, excluding references, argument, or evidence regarding prior gang affiliation. Also, motion in limine 3, prohibiting adding Dr. Alex Avila as an expert witness and barring testimony of Dr. Avila. So those we're getting the specifics. However, the declaration of Peter Anderson does not set forth verbatim exactly first of all, that doesn't need to be in a declaration. An attorney does not need to make a declaration to get facts on the record to proffer information about what's contained in a motion in limine, 2 motions in limine that are already separately filed. They can reference and, for the convenience of the court, pull out the relevant verbatim parts in the argument in the actual filing. But you do not need to do that in a declaration. That's not what a declaration's for. And I really don't think Ron understands that, because when we read his declarations, they're verbatim, word for word recitations of the argument he makes in the filings. like this is stunning to me. And now we're taking an issue that somebody else isn't misusing declarations the same way I misuse declarations. The declaration of Peter Anderson does not set forth verbatim, even though we had, guys, what was happening for like 3 pages above, where we were seeing these like weird, poorly structured. It was hard for me. You want to make sure the reader has a good time, an easy time following your argument. That can get complicated in legal writing because you have all these citations you're blocking in, and you've got to say a lot and try to say it in a smaller space, hopefully. But when you're trying to quote and reference something and you're typing it almost completely and then shifting to an argument about that thing, but you're not using quotations to quote something verbatim, it was just really weird formatting earlier. And now we're taking issue with someone not setting something forth verbatim in a declaration. It's not like this declaration is Peter saying, someone messaged me, quote, and because he's the only one that can provide the court that information, he has to put that quote in a declaration and then reference that information in his argument in his motion. We don't need that because a motion in limine is already on the record. But still, for you to argue that someone should be saying something verbatim when you're just like all willy-nilly, cattywampus with these, and shout, I think, is it Ron or Eli? It's Eli. Eli over on X had sent me a list of cool vocabulary words. Cattywampus was on there, lots of good words on there. So just been having a time marinating on that list. We'll incorporate some as we can. But like, what are you doing arguing about somebody using verbatim quotes? And also, verbatim and exactly is kind of redundant. I don't know if we need to say verbatim exactly. I think we get the point with one or the other. Motion in limine 1 and 3. Let me get off my soapbox about declarations. Yeah, Aaron says I want to slam my laptop shut. What are we doing? Yeah, he's treating the declaration as though it's a formal criminal indictment. He wants it to be. He wants his declarations to be as such. Like, oh my gosh. Yeah, don't ever tell me, guys, I should go to law school and become a lawyer because I could not deal with this. I could not deal with this. Shout out to those out there that are dealing with this. Um, and this is on the heels of looking at what's been going on in like the Fat Joe, Joseph Cartagena dealing with Terrence Dixon and Tyrone Blackburn, where we have more like attorney Tyrone Blackburn is facing criminal charges for attempting to run over a process server. Like, why is this happening? How are we here? I couldn't deal with it. And then it takes forever to deal with these types of things. Like, couldn't do it. Anyway, motion in limine 1 and 3 are also not attached, and there is no proof of the existence of a written order that motion in limine 1 and 3 were granted. Wasn't it granted in court? Okay, you know what? If he's right about this, maybe there's an issue, but what? Why didn't you argue this a month ago already? No exhibits to support the position that motions in limine 1 and 3 were granted are attached to the declaration of Peter Anderson. Because you don't. The declaration is an exhibit that's attached to. We're going to the next paragraph. We've got the hanging emphasis here. Only precise court orders as written may be enforced by contempt. So defendant Cardi B has not presented the court with motion in limine 1 and 3 or a written order granting motion in limine 1 and 3. There is therefore no basis for the court to rule on counts 1, 2, 3, 4, 5, 6, 7, 8, and 9, which are founded on Ron's violation of motion in limine 1 and 3. When were those? Those were back in July. Yeah, I think we need to put on some music, decompress a little bit. Oh my goodness. Let's go back to. Oh, let me get the case number because I closed the docket. Let me pull the docket back up. Mhm. I don't think he's that, see. Oh my gosh. Sorry, I've got captchas going on back here. They never end, and I'm clearly not very good at them. Everything looks like a bus. Alright, I've gotta buy a document. Let's see. Alright, so where are we? Still dealing with oppositions. Maybe it's in here? Because we still have an opposition to number 2 here, but we're dealing with 1 and 3. So let me try this one. Let's see what's in this one after I do another CAPTCHA. Okay, it's 5 pages. Let me buy that because I can't see that. Okay, so let's see. Nope, they're just dealing with the bifurcation issue. Motions in limine. Granted. Oh my god, this guy's stupid. It's on the docket. Why are you arguing this? I cannot wait to see the reply. Do you see? I'm not a lawyer. That did not take me, and I had to deal with captchas because I've been on this site like a million times. Maybe he can't get through the captchas. So maybe he can't see anything that's on the docket. What are we doing? Motion in limine one, granted, subject to defendant not opening the door. But we're not seeing Ron say the defendant opened the door. So I wasn't in contempt. I wasn't violating the court's order. Motion in limine number one, granted. And then we do have a tentative to grant based on correspondence for motion in limine number 3. So let's see. So 1 is granted, 2 is granted in part, 3 is granted. So 3 was officially granted. Oh my gosh. Well, that was worth it. That was worth the 5 buckaroos. Oh my gosh. And I like to, when I have questions, like part of me really wanted to just look at this and say, this can't be correct and just keep going with the stream. But like the 85% of me, it's not like even 99, it was like 85% of me. So 15% of me was like, don't even verify, just assume that this is incorrect. And I'm like, Kat, what are you thinking? Like, you shouldn't just be giving the lead. Go verify it. Go verify it. Well, sure enough, this was wrong. This is incorrect. And it took me just a couple minutes, including captchas, to find out that there were, in fact, orders granting both motions in limine 1 and 3. So that was a fun exercise. But I really had like a little bit of self-reflection internally in that split 30 seconds. I almost kept scrolling and almost just let it rock and let it be in doubt. And I don't like to approach information that way. So glad we verified. It was a good laugh. It was worth it. All right, next we've got Peter Anderson's declaration and exhibits 10 through 25 do not support Ron A. Rose and Janfaza's alleged improper closing arguments or references to facts not in evidence constitute contempt. So we're back again arguing about the declaration and the order to show cause asserts counts 10 through 25 premise on Ron's improper closing arguments and arguing facts not in evidence constitutes grounds for contempt. Peter Anderson asserts that, and we have a quote, guys. We are getting a quote. Mr. Rose and Janfaza's choice to disregard the court's orders in limine and argue facts outside the record after the court's express admonition not to do so implicates the court's contempt power. The declaration of Peter Anderson and the order to show cause fail to cite any specific reference in the record where the court expressly ordered Ron Janfaza not to argue facts outside the record. Oh my gosh. Again, a declaration wouldn't be the place for that anyway. I wish I could watch the judge read this. I just wish I could just like plop myself in his office and he's got, like Aaron said, I got to close my laptop. Just sitting there and just watching him go page by page, looking at it. Like, um, crazy. Oh yeah, Matt says he's alive. Yeah, he did a great job evading service. Did a great job evading service. He was not successfully hidden. Good to see you, Matt. Um, I don't know. Question of the day. Question of the day. Yeah, Marley, this is a great other reason why I can't be a lawyer. Because my reactions, my faces, and I smile when I'm uncomfortable. So like sometimes when I point out, I don't like to just entirely judge a defendant or a witness's body language if they smile during something that seems like a sensitive question, because maybe the air in the courtroom is awkward, or maybe the way the attorney is questioning is confusing and making you make the face at the attorney the way they're asking something, and not just because you're thinking back to this thing you're being asked about and having like a smile in reaction to that memory. But yeah, my faces would be trouble in the courtroom. The sighing, I would I did it just, like, talking out loud, I'd be like this, hand to the face. I'd be hold on, where is it? I don't know if I'd go this far, but I'm sure I would be pretty close, accidentally, to this infamous Takapina clip emote. Could be me, could be me. So, yeah, let's go, guys. Let's see what we've got next. So we finally have a quote, but we're taking issue with a declaration not citing the express order, the court's express order. The only reference to any admonition directed at Ron, Rose, and Janfaza, not arguing evidence, facts outside the record, is reference to the following colloquy between the court and Peter Anderson, Esquire. Um, are we going to argue that just because the court says something during a colloquy that it's not a ruling? It's not binding? It's not. The cited portion of the reporter's transcript does not set forth any oral order to not argue facts outside the record. You're not supposed to do this anyway. Like, if a judge has to expressly order you to do something you're not doing anyway, and your argument is, well, you didn't expressly order me not to do the thing that I'm not supposed to do anyway, where are we? So we have another quote. Mr. Anderson, just briefly, a couple questions. First, as if you remember, counsel violated a motion in limine order. And now he's talking about arguing things that are not in evidence, which is completely improper. Yeah, this is not ambiguous. This is like, the judge should not have to make this is them commenting on you doing something that's completely improper. They shouldn't have to make an express order, write it, sign it, dot it. So, Mr. Anderson continues, I don't want to object every 5 minutes to his closing argument. I would ask that, at least let me say, if the court doesn't want to tell him that he has to follow the rules, he can't argue to things that aren't in evidence. He can violate the motions in limine. So, counsel here is arguing he's violating motions in limine and what already exists that he shouldn't do. So then the court cuts in. The court says, I think it's readily apparent that you can't argue facts that aren't in evidence. Yes. Why would you? This is worse than Janfaza including the email from Peter Anderson saying, like, oh, Peter Anderson was threatening to report me to the bar. But the email memorialized contemporaneously. It was Peter Anderson responding or sending an email. It wasn't a response to an email. It seemed to be an email after a phone call, with Peter starting out by saying, hey, as a reminder, every communication between us needs to be in writing. Don't call me. Not verbatim, but to that effect. And then saying, look, if you're saying you're going to go and do this, call a press conference while the trial's still ongoing, if I don't do something, I just want to remind you that that would be unethical. That would be against the code of professional conduct. Janfaza included that email to the court. The court probably had no knowledge of that incident whatsoever. But Janfaza thought it was a good idea to include that. And now Janfaza here, in this opposition to the order to show cause, is taking a transcript of the court saying, it's readily apparent that you can't argue facts that aren't in evidence, and whining that it's not an express order that I can't do it anyway. Oh my gosh. A cinematic camera angle says, am I tripping, or did the judge sustain the objection and literally tell the jury to ignore facts not in evidence during Ron's closing arguments? And didn't he directly tell him to stop? I know he gave an instruction during closings. I imagine it could have been for this issue. And I know it was objected to. But and I'm not doubting you. What I'm just saying is, it's so jumbled in my mind now. like the admonitions to this attorney and the reminders, right? Not always just an admonition. We're not just bullying you. It's getting to a point where reminding you isn't enough. This is ridiculous. So now it's admonishment. And it happened multiple times throughout the trial. And yet we're reading this filing where Ron's just like, nobody ever told me, so I could just do whatever I wanted. Like, and that too. Like, with a transcript, if we're gonna switch to the court, maybe let us know more easily that, Mr. Anderson's speaking and this is all attributed to Mr. Anderson, and then put this on a separate line when the court starts speaking. So, I don't know. I don't think a clear understanding is the goal here, though. It is very strange, very, very strange. And Touche, I have questions too. Um, I know that doesn't seem kind, but I have questions if this guy's like okay, if he's going over the edge, if there's something going on, because this just doesn't seem like an entirely stable approach. And then knowing the additional context where he's had issues with the glasses and the mistrial, and then the issue with the janitor, it's like, I don't know, I don't know. So, I don't know. If there's something going on, I hope that wish the best. Wish the best. And I have no opposition to people figuring things out, things aren't okay, and making a turnaround for the better. All right, so we were reading the court. We read this. It's readily apparent that you can't, I think it's readily apparent that you can't argue facts that aren't in evidence, and the plaintiff's counsel knows that. Does he? I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside the evidence that was presented in court. And he's bolding this. So Ron is bolding the next part from the court. If he wants to present that and you want to object, then that's how we'll proceed. The court then inquired if there was anything else from plaintiff's counsel, who responded, "What? This is a weird way to format this again." Because then he says, "Plaintiff's counsel who responded," but then he cites the court saying, all right, anything else from plaintiff's counsel?" Then Janfaza, "Yes, Your Honor, I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence." The court, "I think you just said you were going to." Janfaza, "No, I didn't say I was going to. The court told me that I can argue the issue of the photograph, that it wasn't taken on the date." Oh my God, this is about the nails. This is about the NBA All-Star game. The court, "Correct. Your position on Wednesday was that they didn't establish the right date, and you can make that argument." Janfaza, "That's exactly what I wanted to do." The court, "Okie dokie. An isolated act of misconduct may not be contemptuous absent a prior admonition." I thought some of this, what was the counts that this applies to? Because it wasn't just about, yeah, so this is supposed to address counts 10 and 20, 10 through 25. This wasn't just on the issue of the mention of the date of the NBA All-Star game photograph. But I guess we're going to act like that's the only issue, even though we said counts 10 through 25 when starting this argument. Um, so he says an isolated act of misconduct, because we're choosing to only address one of the 10 through 25, may not be contemptuous absent a prior admonition. The record is devoid of any admonitions to Ron Janfaza to cease arguing facts not in the record. To the contrary, defendant Cardi B's submitted evidence in support of counts 10 through 25 does not support a finding that the court admonished Ron Janfaza for any improper argument to the jury. I mean, if this needs to be spelled out to you, you were told, the way I look at this, you can only make that one argument, and you're only addressing this one issue by including this transcript. The first time we're seeing you include a transcript, um, and ignoring the rest of the other counts. And all the preceding conversation to this was the court saying, I think he knows that it'd be violating the rules for him to do anything further. So this is, what are we doing? Ron Rosenjanfaza, this is next section, was never, quote, personally served with the order to show cause, re contempt. The court lacks personal jurisdiction over him. Ron Janfaza, why would you do this? This looks like you are conceding that you were, in fact, evading service. Why would you do this? Why would you do this? Ron was never underscore bolded, personally served with the order to show cause, which is required. See the declaration. We still haven't read the declaration. Unless the citing has concealed himself from the court, he must be personally served with the affidavit and the order to show cause. You've been deemed served by the court. Otherwise, the court lacks jurisdiction to proceed. Ron respectfully submits that defendant Cardi B's affidavits of service, exhibits 4 through 11, filed in support of granting the ex parte application, which has been granted, did not demonstrate that plaintiff's counsel was evading personal service. It doesn't matter. It's been granted. You need to file a motion for reconsideration if you want to take issue with this. Defendant Alamanzar supporting exhibit, and maybe put a footnote here that you're contending that this is still an issue separately, but it's not an argument placed within an opposition to the order to show cause at this point. I don't have a laptop to slam closed. I don't know. So he's arguing that the order to show cause did not demonstrate that plaintiff's counsel was evading personal service. Cardi B's exhibits 4 through 11 contain inadmissible hearsay in an attempt to circumvent the requirement of personal service. So the affidavits from process servers, and there were also 2 individuals that seemed to be part of like a third-party global servicing company, I forget the name, are now inadmissible hearsay. If that was the case, then the court wouldn't make it a procedural step. Get a process server, attempt to serve. Have you used a third party? Have you tried having the sheriff's office serve somebody? Have you tried doing these things? We need affidavits showing that you've made the attempt or that the individual you hired to make the attempt made the attempt. Well, the court wouldn't require these things as part of a necessary step for the analysis in a consideration to grant alternative service or grant a request to deem someone served. So now Janfaza is arguing that because he says so, the normal and standard practice of what to do if you make several attempts to serve somebody and do not succeed, he's just saying, well, affidavits to show you've tried just should be inadmissible hearsay. This is wild. This is wild. The affidavits of service exhibits 4 through 11 do not contain admissible evidence which would support a finding that Ron sought to evade personal service. Does he understand like that evidence isn't necessarily a proven fact, it's a fact that goes to show the truth of the matter? Because that's exactly what an affidavit's purpose is. The affidavits of service do not evidence that plaintiff's counsel in the past avoided subpoenas or notices, that he instructed others to not accept documents, proof that Ron Janfaza altered his routines to avoid service, testimony that Ron left through back exits when servers arrived, phone records showing, like, these are examples of things that you could include to demonstrate something. But just because it's not observed that you engage in one particular behavior doesn't mean that all of the other presentations and representations don't count for anything. Oh my God, he's going to argue also phone records showing Ron's awareness of the pending service, or phone records, awareness of the pending service. It's on the docket. It's on the docket. For a case that you're still actively litigating, you just filed a motion for a new trial. So there's reasons for you to be paying attention to the docket and paying attention to correspondence relating to this case that you get through email or to the Tilly at Beverly Hills email address. This is crazy. This is crazy. I don't know if this is desperation or serious or both. Multiple attempts at different times of days. That's the affidavit pointed that out. Evidencing, because remember they had different court appearances and they had one guy at one appearance, one courtroom, and one at another. And it was like the clerk ended up saying it was remote appearances by the attorney. So those were multiple attempts at different times during the same day and also across different days. Evidencing that the party was present but refused to answer the door. Well, they tried to suggest that the a known address that he still uses, neighbors or co-occupants confirming the party was inside. This is crazy. Conclusion, the OSC must be dismissed. I don't know if you got me there, buddy. Counts 1 through 25 are all premised on acts which were in view or in the presence of the court, which acts, if true, would constitute direct contempt, which may only be commenced by the court, either summarily adjudicating the contempt at the time it was performed, or otherwise by setting an order to show cause, re-contempt, in accordance with Code of Civil Procedure 1211A. And again, that's the only thing he's argued. He didn't argue any of the other statutes relied upon in the order to show cause. The present order to show cause was set pursuant to Code of Civil Procedure 1211A as an indirect contempt, and the charges set forth in the declaration to Peter Anderson. I don't think the words indirect contempt were in quotes in the order. I guess maybe he's just putting that in quotations here. The acts complained of regarding Ron, all are admitted having occurred in the presence and view of the court and therefore constitute direct contempt and not indirect contempt. In addition, Ron was never personally served with OSC, and the charging declaration / affidavit of Peter Anderson and supporting exhibits lack sufficient specificity to give notice of the charges against Ron Janfaza. Motions in limine number 1 and 3 are not attached as exhibits, and no evidence is submitted that the motions in limine 1 and 3 were granted, and no order or minute order is submitted to prove such motions in limine 1 and 3 are valid orders to support a charge of direct contempt, let alone indirect contempt. How are you arguing that everything should be direct contempt and that the order was only made for indirect contempt matters so that the court doesn't have jurisdiction? Meaning everything's direct contempt. The court is aware of it. It's on the record somewhere. But then you're also arguing, but what about motions in limine 1 and 3? We have no evidence that they were supported. We don't even know if they're valid orders. It's like he's arguing both ways again. Guys. Hey, One Girl Melly, good to see you. Hey to Antonio Anthony. I love this name because it makes me think of the Munktunk confusion where they confuse him with Anthony Sledge, even though he's Antonio Sledge. So I love the name Antonio Anthony. Hope you're doing well. Oh, we're not upgrading his name to Captain Ron. I would not trust him with a ship. I don't want him steering a ship. Oh yeah, and destined to be. Yeah, let us not forget. Remember when he tried to say he doesn't do a lot of trials and apologize for his lack of knowledge? I don't know. I mean, I remember him saying that. I don't believe that he has that as a valid excuse. But he didn't really try that here, though. So, as a matter of due process, Ron was not personally served with a copy of the OSC of October 20th, 2025 as ordered by the court. Therefore, Ron Janfaza did not have sufficient time to respond to the charges of contempt. This is your response. Are you going to ask for a remedy to be able to provide like supplemental arguments? Or what's the issue here? Because you're responding. So how are you arguing that you didn't have time to respond? This is the response. For all of the above reasons, the OSC must be dismissed. Furthermore, there is no evidence to support a finding that Ron Janfaza willfully violated any court order or committed any acts which may constitute contempt. There is no admissible evidence that, because we can't use the affidavits. Affidavits are not admissible evidence, apparently. That Ron was ever admonished that his closing argument, different issue, and that his closing argument in reference to evidence was improper. Plaintiff's counsel respectfully requests that this honorable court refuse to hear said OSC and dismiss it with prejudice in light of the above and lack of jurisdiction, which is respectfully not being waived by plaintiff's counsel. So there we go, and we have a declaration. So let's see how much of this declaration repeats. How long is this? Oh my god. uh yeah, I'm pretty sure he's going to repeat arguments in the declaration. Um and he didn't really cite the declaration all that much. Destined to be, I think we might get some references to his experience here in this mess. Hey, I am Shout. I've been shouting a lot in this reading of Janfaza's opposition. Good to see you. All right, so Ron, declare as follows. I am an attorney at law duly licensed to practice before all of the courts in the state of California. I'm attorney of record for Emani Ellis. I have personal knowledge of the facts set forth in this declaration, and if called as a witness, could and would testify competently to such facts under oath. The parties have always agreed and served all documents. Oh my god, we're repeating this. This is the exact. He's repeating the whole thing, guys. We're going to skim this because this is going to be a repeat. And again, why are you doubling down? You just cried that you were not personally served, even though the court has deemed you served. And you're again arguing that the parties have always agreed and served all documents via US mail or personal service, although, and then courtesy copies sent via email. So he's going to argue this issue. Aha. Now we're getting a change. This is different from what he wrote in the beginning of the motion. Here he's saying defense counsel agreed that he would request an order to show cause recontempt no later than 30 days, according to this declaration, after September 2nd, 2025, which falls on October 2nd, 2025. Above, he said the court ordered 30 days and didn't give a date to start the clock. And now it's defense counsel agreed. And it's unclear. Did defense counsel say 30 days from September 22nd, or did he say 30 days from the judgment? Which to me is a normal procedure. And the official judgment was filed it was like the 16th of September. They proposed like the 5th, but it wasn't actually filed. And then there's something on the docket from the 16th of September where it was noticed to the parties officially. So who knows? Who knows? I think that we might just be getting an insert from Ron of this September. He's including that this was not the defense, and it certainly is no longer even being represented to have been the court that declared a 30-day timeline. The 30-day timeline seems procedural, and typically that clock starts when the judgment is entered into the record, which is not the exact moment that the jury says we have a verdict and it's read. Defense counsel served his request for an order to show cause 1 day late on October 3rd. The order to show cause set on December 5th against me should be denied for this reason alone. Again, this is an argument. This has no place in a declaration. There's no place in a declaration to be making this argument. Attached here too is Exhibit 1 is a true and correct copy of the proof. So in his declaration, he's also citing the exhibit that he cited in his filing. So he's referencing the same Exhibit 1. What are we doing? And then the envelope is Exhibit 2. Then all of the other documents to show other times where the date of the envelope, the date of the postmark, matches the date of the electronic filing. And the representation that that's when I served. Now, declaration. I have never been personally served with these applications to show cause or the court order on October 20th. And I haven't been served with the minute order. He's saying I haven't been served with the minute order for the appearance that I did not appear for. I didn't appear for that hearing. The court was wondering why I didn't appear or communicate with the court. And I wasn't served with this minute order, but clearly I'm aware of it. And that's the minute order where it's deemed that he was served. This is crazy. I did not evade personal service in this case. I did not avoid subpoenas or notices. I did not instruct others to not accept documents. I did not alter my routines to avoid service. I did not refuse to answer the door. The issuance of an order to show cause against me is extreme and inefficient. Contempt requires my conduct to be willful. I have a tremendous respect for this honorable court. I did not intend to disrespect this court. My conduct during the trial in this case was not willful. Here we go, destined to be. I am not a, quote, seasoned trial attorney and did not intentionally attempt to violate any court orders. I apologize in advance to this honorable court for any errors made during the course of the trial, which lasted from August 25th to September 2nd. My law license is the most important thing to me, which I would never sacrifice for any reason. I previously proceeded to trial in approximately 10 different cases in my career as an attorney. Yeah, because you expect settlements. I also served as co-counsel in several cases in my career. It was never my intent to intentionally or willfully attempt to seek or violate any court orders. It was never my intent to intentionally, my intent to intentionally is crazy, or willfully violate any court orders. I sincerely apologize in advance. You just said you didn't do anything. I sincerely apologize in advance to this honorable court for any errors I may have made during the course of the trial. So if you find I made a thing, let me apologize now, even though I'm just telling you shouldn't find any errors. I was simply asking questions to the best of my abilities in a good faith effort to zealously advocate for my client. I did not ask questions in an attempt to elicit testimony which forms the basis of defendant's order to show cause. It was never my intent in closing arguments to appeal to the prejudice, passions, or sympathy of the jury, nor to violate any court orders. Any errors I made at any point during the trial of this case, including my closing argument, were mistakes. Just like a blanket apology. Adventure Aaron says you sent a magician to the door. Yeah, Destin to be. You got it. I mean, he did reference it a little bit, but like, you would think, I guess he didn't flesh these arguments out as much because he already had filed a response fleshing out like, please, 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 I am not a seasoned attorney. My law license is important. Please don't report me to the bar. Please don't sanction me. All right, so now we get this is a bit different than how it was worded in the motion. He's addressing the issue with count 1 raised by Peter Anderson in the order to show cause. He says, I asked one question about any current gang affiliation. This line of questioning was drafted by my office manager and asked in error. I take responsibility for not having paid closer attention to my formulation of questioning of defendant's witnesses. So this is repeating what we heard in his other response and declaration, one of many. My question was immediately objected to, and I did not pursue further questions in this area. I confess I made a rookie mistake asking this improper question, but it was not asked knowingly to violate any order of the court. It was not asked to willfully violate any court orders. Count 2, there were so many trial documents being exchanged, including the witness list, that this must have been filed in error. I was not seeking or willfully attempting to present an improper joint witness list to the court. Counts 3 through 9, defense counsel inaccurately claimed I asked improper questions about Dr. Avila. On the first day of trial on August 25th, I asked questions regarding Dr. Avila, which were overruled by the court several times. All of the times or several times? Based on the ruling, I believe there was no issue with discussing anything related to Dr. Alex Avila. Attached here too as Exhibit 4 are true and correct copies of page 150 through 151 of the relevant portions of the court reporter's transcript. So let's go look at that. Exhibit 4. All these letters. Hey, here's all the times you tried to serve me. All right, so this is the beginning of the transcript part. We have an answer, I do. Question, do you remember that there was a period of time where elective medical treatment was not allowed? Yes. What about the cost of the treatment? Could you afford to pay, I don't know, $15,000, $20,000 to get plastic surgery to your face? No. Did Dr. Mulliken agree to treat you on a lien basis? He did. And when you got medical treatment on a lien basis, is it your understanding that regardless of the outcome of the case, you still owe Dr. Mulliken the fees for the treatment that he did? Is that your understanding? Yes. Did you also see a pain management doctor for one visit? I did. Did you also treat with different psychologists, including Alex Avila and other psychologists, on October 8th, 2022 through July 2nd, 2023? Anderson, objection, a violation of the order granting the motion in limine. Overruled. The witness, I'm sorry, can you repeat the question? So he repeats the question. Anderson says same objections and it's overruled. Correct. Yes. And for that psychological treatment, did Dr. Avila's office agree to treat you on a lien basis? They did. Yes. For Nicole McKenzie, did you? Were you the medical bills? All right. So this one goes to a different doctor and there's a sustained objection. I think he's just including the page to finish out that part of the transcript. So, but this isn't addressing. Didn't he also mention the doctor during closings? Because this is testimony, not closing arguments. So, but let's see. I mean, maybe that was one of the counts of the range. And we were on like page 24 or something. Yeah, okay. So this is supposedly to address counts 3 through counts 9. So I don't know how that one little bit of transcript addresses all of those, but okay. Counts 10 through 25. I presented a closing argument as best I could. Oh, this was a televised case with high emotions and very little sleep. The case had very little sleep. I also went to the California ALA convention. Oh, maybe that's not California. CAALA convention in Las Vegas, Nevada over the Labor Day week of August 30th through September 1st, just before I gave my closing argument on September 2nd, which made me more tired than usual. Okay. Defense counsel argues that my closing argument was presented in an effort to willfully present facts outside of evidence. I did not willfully intend to present any facts outside the evidence. Any such statements were errors. And then all of the counts 1 through 25 stem from actions. He's going back to the direct contempt. The only reference to any admonishment directed to me, not arguing evidence, facts outside the record, is reference in a colloquy between the court and Peter Anderson. Attached here too is Exhibit 5. Are true and correct copies of pages 44 through 46 of the relevant portions of the court reporter's transcript. Defense counsel agreed on the record that he would request an OSC against me no later than 30 days after September 2nd. All right, so that's actually cool. He has a transcript. So this could put my complaint to rest and be a win for Janfaza. He said, the Exhibit 6. All right, so Mr. Anderson, yes, Your Honor. Although you cautioned counsel that he can't argue things that are not in evidence, he repeatedly did. He even started talking about Dr. Avila's treatment, even though he was excluded over and over and over again. And all the jury sees is me objecting and Your Honor sustating it. I would request that you admonish the jury to disregard all of the statements that you sustained objections to. So this is where we're getting, I think this is exactly what cinematic camera angle was recalling. So this was a specific issue. I would request that you admonish to the jury to disregard all the statements that you sustained objections to. I would also ask that you assign misconduct to counsel and that he be reprimanded because this has just been ongoing. The court, okay, we can discuss. So it seems like court's going to say we can discuss, some options here. He's not going to make an immediate decision. Janfaza says, I want to respond. Well, let me do this. I will give further instruction to the jury about that the argument of counsel is not evidence and that they should disregard any comments that were not supported by the evidence. I will give that instruction. We can discuss whether or not we want to set an OSC after the trial for any alleged conduct. So this is what we have highlighted in red. That's the end of it. So I mean, there's more included, but it's not highlighted. So he's only highlighting certain parts. Let's keep going. So we're going to continue following from where he stopped highlighting. Anderson says, thank you, Your Honor. Miss Moore says, Your Honor, may I please say one thing, please? The court says, go ahead. Miss Moore says, I just want to note that you advised Mr. Rosen that if he were to argue to the jury that Cardi said that photograph was taken on February 24th, that would be a knowing violation of professional rules, and that's exactly what he did. The court says, okay, well, Mr. Rosen Janfaza, I want to respond. The court, why don't we? I don't want to do it now. Janfaza, well, I have to say something about it. The court, you don't. I've said we'll discuss whether or not we want to set an OSC, and we will address it then. So this goes to when we looked at that order to show cause, and the court's like, I'm taking these other things from Peter under advisement, but the court also already has this in mind and has said we're going to set this for a later date. We're not going to let this interfere with the trial proceedings. Um, we're going to give the instruction, which is a normal instruction, and we're going to figure this out. You're going to have an opportunity to respond then. And we've seen that he's filed 2 oppositions now at this point, even though he's pretending wasn't aware, he wasn't served with anything. And then he also not only has the order to show cause hearing to discuss the matters, but he's also insisted, well, December 5th should also be the day I get to argue for my motion for a new trial. So what do you want? Which way are you going with it? But yeah, it's interesting that this stuff isn't part of the highlights. So Mr. Anderson says, thank you, Your Honor. Janfaza says, okay. Then they take a recess, which is normal. Like the bench notes in California, not every state has like thorough bench notes, but California is super thorough with them. They advise the judge, like, hey, why don't you like take a second and cool off? Go think about this. If you need to take a recess and figure out what you're going to do, if you're going to address it right now, if you're going to set a hearing, come with those decisions. So they take a recess. So the court says we're on the record outside the presence of the jury. So jury goes out. Counsel are present with the parties with respect to speaking with people is that it's got to be a reasonable time and place. And so if people start bothering you, did this jump? Oh, okay. So this is them excusing the jurors, and it's missing some of the instruction to the jury not to talk to anyone while they're excused. So then the court says we're going to have an OSC in order to show cause regarding a proposed judgment on the jury verdict. Oh. Okay, so this is a separate matter. Can I have defense submit a proposed judgment on the jury verdict for 9/16 at 8:30? See, how are you including this transcript? And again, he didn't highlight this, but this goes to the issue of the assertion that the clock starts on September 2nd for that 30-day window to file an application for an order to show cause. So he continues, the court continues, if a proposed judgment is filed, that will go off calendar. Rosen Janfaza, Your Honor, I believe that's around the Jewish holidays, so I want to take something in later in October. So he asked for more time. It's the date for him to file a proposed verdict. Janfaza, is there a court appearance? There'll be no court appearance? Correct. All right, thank you. So he knew. He knew that this final judgment, the clock isn't just going to start on September 2nd, and yet we saw like 6 pages of argument devoted to this. Oh my gosh, you guys. I'm just over here yelling at the screen. Glad you guys are here. I'm not yelling at you. I am yelling at my screen. Hey to Kay Sierra. Oh, and Kay saying thanks for the membership. Idiot Win, the gifting 10 memberships. Thank you so much. Are these 10 counts of potential things someone should show cause for? Thank you so much, Idiot Wind. Super generous of you. Hope you're doing well. You always seem to show up on streams where I'm yelling at the screen. So let's get Idiot Wind in the banner. Oh, I can't spell. I cannot spell. Thank goodness I can't bold and underline things in banners. It would be a hot mess. So thank you so much again, Idiot Wind. I'm seeing everyone say thank you in the chat. Thank you guys for always saying thanks when people are so generous and gift memberships. I'm gonna cry. I'm gonna cry laughing. I love this. Cinematic camera angle says, by the way, I just used the LA court deadline calendar calculator and 30 days from September 2nd. So even if we started with the September 2nd clock, it would take us to October 15th. And, presumably that's like holidays, time off, weekends not included. So If that's how California does their court math, that's even funnier that he's arguing this. Because that means there's like a fourth reason why his argument about the October 2nd and 3rd thing is flawed and or irrelevant and or not timely. So, and again, he filed his deadline. He's saying the deadline for his was the 17th, which is in the order. The date is given in the order that his deadline to respond with this opposition is the 17th, and he filed it after business hours. So the louder you scream about something, the more scrutiny, the more of a lens I'm personally going to put on your own behavior. So thank you for looking this up. That's hilarious. That is hilarious. And thank you again to Idiot Wind. Let me scroll this up so keep Idiot Wind on the screen for a little bit. So again, he's not highlighting any of this. All of the stuff that we just read was between his highlights. It's like he doesn't want to put emphasis on, hey, we're not actually going to start this clock rolling. And maybe they do. Maybe they do backdate it to the 2nd, but it doesn't matter anyway because it wouldn't take you to an even 30-day October 2nd timeline. And again, we don't have anything in quotes that says the court said any applications for order to show cause, because at first in his argument, he's representing it as the court's requirement, the court's order. Doesn't give a date, doesn't give the specifics, just comes up on his own and says it should have been October 2nd, but it was really postal stamped for the 3rd. Then in his declaration, he says, well, it was actually the defense counsel for the defendant, saying, I'll have it to you within 30 days of the judgment or whatever. Well, that's a different thing than how you represented it in your argument. And it's weird because his declarations historically have been like, the segments of his declaration will be verbatim what's in the argument. But the wording was different. So something's a little fishy about that. So this highlighter, we're getting back to highlights now in the transcript. The court, all right, anything further? Why don't you do, if you want to request an order to show cause regarding attorney misconduct, you can request one. Let's see. And the court will determine whether or not it wants to set one on its own. So this is highlighting like a hybrid contempt possibility. So if you want to file a application for order to show cause, you can do so. And the court will also determine whether we're going to do one sua sponte. So this whole time, Janfaza is arguing about the issue of direct versus indirect, in my opinion, misrepresenting what's contained in the order to show cause from October 20th. And then he includes this transcript, and it's actually highlighted that the judge is saying, you can request one, attorney, and the court's also going to decide if we want to set an order to show cause on its own, which it ultimately does. Now we're going to get the 30 days. So, okay, the court does say, Anderson says, okay, is there a deadline for that, Your Honor? How about within the next 30 days? That's fine. Plaintiff will do the same, and plaintiff reserves the right to appeal. Thank you, Your Honor. So we're highlighting this for the 30 days. So we do have about within the next 30 days from the court. So that's a slight like plus 0.5 for Janfaza. Then this isn't highlighted. Oh, well, one more line. So Janfaza says plaintiff will do the same. Because remember, he said he's going to file, and he waited to file until October 3rd. So he's out of the deadline. What the heck? Okay, guys, what's on the screen right now? We need to go back to the docket. I'm not crazy. Let's go back to the docket. If he's arguing, how is this not outside the time frame? So this here, what's on the docket as being received on October 2nd, is the application from Cardi B's attorneys for an order to show cause against Ron. This is what Ron's taking issue with. It was late because it was said 30 days. Here's the transcript. I'm highlighting it now. Court said, how about the next 30 days? Even though the docket gets it on in 30 days, he's arguing he wasn't served by mail. until the 3rd. But then he says in this transcript that he's highlighting he'll do the same, meaning the same 30-day window. And it's on the docket for the 3rd. So what are we doing? What are we doing? Because this is his petition. This is Ron's petition for an order to show cause against Peter Anderson. So not only is it late, it looks like it's just a response. Oh, you filed one against me. I'm going to file one against you. This is hilarious. So back to the transcript. I think this is probably the end of it. So, I mean, does it say anything else interesting? Talking about the exhibits. This is funny. Okay, so the court's like, all right, thanks. And then the exhibits, the plaintiff's exhibits. You wanted the plaintiff to keep and then Anderson, Cardi B's attorney, says, plaintiff, I apologize. Plaintiff wanted to keep the exhibits. Defendants would like to keep them. There was a lack of trust. In that case, the court will keep them. How's that? Anderson says, absolutely fine. Rosen says, thank you, Your Honor. Anderson says, thanks to the court. Court says, all right, I appreciate that. Anderson thanks the staff. Court says, all right, thanks. And then they proceed. That's the end of the transcript. That's crazy. That is crazy. Like, how are you emphasizing that your own filing is late? Actually late. Late to the court. Not just late in one of the several ways that you could be in receipt of the filing. We were somewhere towards the end of this declaration. We're going to get more content for Destined to Be. Let's see. All right, so this is the 30-day thing. Defense counsel agreed on the record that he would request an order to show cause against me, and plaintiff counsel also agreed. We're leaving that part out of the declaration. That's really funny. He just says defense counsel agreed to the 30 days, which would be October 2nd. Defense counsel got it in to the court by October 2nd. He made the request within 30 days, October 2nd. You did not, and you are not including that you also agreed in that same transcript. I'm going to wake up at like 3 in the morning and be like, Ron, how did you, stupid argument. Just thinking about how stupid this is. Next, I have high regard and respect for this court. Well, you didn't make your filing on time, and you're hiding behind blaming someone else who filed it on the supposed deadline when you filed it a day late. I have high regard and respect for this court and the judicial process, which I believe I have shown that throughout these proceedings and other proceedings. I accepted this case from another law firm to give the plaintiff a fair hearing. Let me move myself down here. Even though it has cost me thousands of dollars despite my financial difficulties. I am not asserting this as an excuse for my behavior, but merely to aid the court to understand the additional stress I was under with a high-profile case, which is not the normal arena I practice in or are accustomed to in my practice of law. Yeah, you're worried about a high-profile case, but you want to do a press conference if you don't get a settlement from opposing counsel. I wish to have this honorable court understand that my actions in court have always been governed by my abiding belief in the dignity and respect I and attorneys owe to the courts and public, and I take my professional responsibility seriously. The most important thing to me has always been to be a credit to the bar. I previously proceeded to trial in approximately 10 different cases in my career as an attorney. I also served as a co-counsel in several cases in my career. My future career path is to be a judge, and we heard about this in his other declaration, in an effort to help people by administering justice. Taking cases to trial is rare and requires attorneys to be willing to do so without fear of reprimand. The chilling effect. I will be taking a trial advocacy class to better understand how to proceed to trial. I'm willing to provide this honorable court with proof of completion if that will satisfy the court. I apologize. I think this is worded differently than in the other declaration. Because this is more like, I'm going to take it. And I remember it previously written more like, I'll do it if it gets me off the hook. This is more worded like, I'll do it anyway and I'll provide proof if you want. I apologize in advance to this honorable court for any errors made during the course of the trial, which were never intentional or made in bad faith. Now we're addressing Civil Code of Civil Procedure 47B, which provides that the court may, upon any terms as may be just, relieve a party from a judgment, dismissal, order, or other proceeding taken against him or her through his or her mistake, inadvertence, surprise, or excusable neglect. And he included, like, this is again, included the same thing in his argument above. My declaration reflects, this is your declaration. This is your declaration, and it's the same wording referencing your declaration. Oh no. My declaration reflects that the errors were due to my mistake, inadvertence, surprise, and or excusable neglect. The aforementioned errors during the trial were due to my mistake, inadvertence, surprise, and or excusable neglect for the reasons stated above. Yeah, I think this was just copy and pasted, perhaps, from the argument, but okay. In consideration of the reasons set forth above, I respectfully request that this honorable court deny the order to show cause recontempt against me so I can move on with my life. Yep, that is why we dismiss things. The parties had their day in court. You're filing a motion for a new trial. The parties had their day in court, and there was no prejudice for my mistake. Anything different would be a windfall to defendant. I also respectfully request that no sanctions be issued against me because my errors during the trial were due to my mistake, inadvertence, surprise, and or excusable neglect. Defense counsel served his request for an order to show cause 1 day late, so we're back to this, on October 3rd, which should not be considered. I respectfully request that the order to show cause set on December 5th at 10 a.m. be denied for the various reasons outlined in my opposition and timely filed with the court. It was filed at 6 p.m., but okay. I'm only scrutinizing that, by the way, because he's scrutinizing lateness. But technically, it was served after the close of court. So it technically got there before midnight, but he's not giving that same lens when he's looking at Myra Izzo's representation about the October 2nd request. Not service, but request for the application for an order to show cause. So I can't see the response to all of this. Like, I can't wait to see. And again, the 26th is the window of time for Cardi B's team to respond to this opposition. So let's get together next Wednesday and talk about that. If it's filed late, it'll have to be a Thursday stream, but we'll see. But yeah, I can't wait for that. Can't wait to see what the court says. I hope December 5th, I hope there's like cameras in there to cover it. We'll get together, whatever we got to do to cover what goes down that day. It's a lot. And then we have, I'm thankful and grateful that this honorable court has given me the opportunity to take plaintiff's case to trial before a jury of her peers. Plaintiff and I appreciate this honorable court, which has given plaintiff a sense of closure and peace. She's filing a motion for a new trial. Oh my gosh. What if he suggests dropping the motion for a new trial to avoid sanctions or something? Like, what is going on? Because this doesn't align with your client and you on her behalf filing a motion for a new trial. What changed between you filing that motion for a new trial just a few weeks ago and now what I'm reading here? Is this just completely disingenuous? You don't actually appreciate this court. You're representing that your plaintiff has a sense of closure and peace, but you know that she does not because she's continuing to pursue litigation. Or are you confused? Was there a change of heart? Because that's the kind of thing maybe you want to write about at the same time or before you file this. The matters set forth in this declaration are true of my own knowledge. They are your own feelings, except to those matters which are stated on information or belief. And as to those matters I believe to be true. That's the whole declaration, really, is the matters that you believe and how you feel. So he declares under penalty and perjury that this is true, correct, and he signed this on Monday. So there you go, guys. We did it. We got through 56 pages of Ron and Ron arguments and beliefs. So what do you think, guys? You want to rate that on a scale of 0 through 10? I usually say 1 out of 10, but I'll give you guys a 0. Feel free to rate that argument. Shannon's in the building. Good to see you. Happy Wednesday, everyone. Hold on, wait, do I have it ready? Or is it?
Oh, guess what day it is? Guess what day it is? Huh? Anybody? Uh-oh. Guess what day?
Oh, it loops. It's gonna keep looping on me. So there we go. What is a negative zero? What is a negative zero? Hey, Alice, good to see you too. Oh man. Latanya says Cardi's gonna countersue her and she will win. And that's the thing. Cardi B said she's gonna give Emani Ellis a pass, but warned everybody else. And then now you're just pushing her buttons. Like, if nothing else, I mean, what is she gonna collect on? But like recouping her attorney fees? I mean, is Ellis gonna make good on that judgment? I don't know. I don't know. So I feel like it would be a waste of Cardi B's time and resources, but at the same time, I like to like imagine, hypothesize the things I would do if I had the money to do certain things. And I think there's a few things that I would do on principle if I could afford to do it. And if I was in Cardi B's shoes, I can imagine myself being like, maybe for the principal, even though this is going to be my money and my time, maybe this is pushing me to the point where even though I know there's nothing on the back end, I'm going to do it for the principal. And it's just crazy. I don't get what Imani Ellis is getting out of this. I think this is a product of this being a contingency case, and perhaps Ellis feels she has nothing to lose because she's not paying like billable hours for Ron to do this. But it's embarrassing. I think it's embarrassing. I would let it go. I would all the way let it go, even if it was on contingency. But that was a time. Hey, I am pretty damn gangsta. Good to see you. And Adventure Aaron says the CAALA, which I just did not know what it meant, is Consumer Attorneys Association of Los Angeles. Oh, so they just held an event over. It said it was in Nevada, right? So they must have just all gone to Nevada. Maybe I read something wrong. But yeah, must be a big or and I wouldn't be surprised, Los Angeles and consumer law. But enough of them to make it worth going over to a big convention in the neighboring state. Yeah, that's what I'm saying. Alyssa's Cardi already warned people to stop playing with her. I mean, and again, this all stems from an alleged assault and battery that from the facts introduced at court, I think it's plausible that if the accusation was the other way around, and again, there's still the issue of like, this was 2018 and we're bringing this forth in 2025. Additionally, I know with the context, it wouldn't be the expectation that Cardi B could be suing for a money grab because she's rich. So I think, but if you even the context and took those factors out, I wonder if it was just two regular people. Cardi was a normal person out of town, and for whatever reason, Imani Ellis wanted to go take a photo of her. And this was brought to a civil case by Cardi instead of Imani Ellis. I think a jury could feel like Cardi B was at least harassed or like her privacy was violated. And it seems like there may have been some touching, but it was initiated by the other person trying to push up after she got called a bitch. I don't know. I can picture a jury, there being facts on the record where a jury is sympathetic in the opposite direction if this case was brought differently. So, by the other side initiating it. So, I don't know. Oh, touche. Touche, touche. Maybe this lawyer and client feel like they're getting fame from this. Otherwise, I really don't understand what they're doing. I don't know. I mean, maybe they're hopeful that people aren't paying attention to these filings. I mean, I watched the trial casually, and I know there were plenty of people watching it, probably way more than are reading the filings. Um, I can imagine Emily D. Baker. I'm sure she's got a ton of stuff she wants to cover with like Karen Reed and all of those. Because if you guys missed it, Karen Reed's like suing everybody. She's suing all of the how they're calling it the House defendants collectively, but she's also going to be adding the municipalities to the filing when the time period allows. So she's going to be suing, I would assume, maybe police department, maybe Canton. I don't know exactly how she's going to name the parties, but there were footnotes saying like we're going to include those parties when we can. Um, so I imagine like Emily D. Baker is uh, probably busy with that, but I hope she gets caught up and does a breakdown of these recent filings. And that's a huge channel, right? So that would be several thousand. Yeah, a lot of her videos on replay exceed 100,000 views. This is not the kind of publicity or spotlight I would want. But again, maybe he thinks that the trial is what people paid attention to and that this won't have any, nobody's going to bother to read it. But here we are. Here we are reading it. So, yeah. And then she says she wants to go to law school. I mean, are we learning? Are we learning? I think one of the most important things in a lot of professions, um, in a lot of decisions, in a lot of business decisions, is picking your battles, picking where to put your resources and energy, picking what fights you want to fight. And some of that isn't just skill. Some of that can be learned through mentorship and experience. Some of that is just kind of more innate and instinctual. And if you don't have good discernment and you don't practice to have better discernment, I think you're going to be lacking a critical skill when it comes to, being a trial attorney or even, you know, attorneys that do things that, aren't necessarily taking it to trial. It's a really important skill to have in a lot of industries as well. But when it comes to the legal field, an attorney's lack of discernment can cost a client a judgment, an outcome, can cost them tons of unnecessary billable hours. So, but yeah, I think I'm not sure if Amani Ellis has that picking your battles thing down. Oh no. So guys, we talked a little bit, and if you haven't been around for some of the like post YSL trial streams where we've talked about other things going on in Fulton County, Shannon has shared some of her experiences with how long the process has taken for something she's dealing with in Fulton. And you thought you had movement, right? You thought the last update was you had some movement. So there's some movement, there was some movement. There was an ankle monitor. They had the defendant. But look what Shannon's saying now, and thank you for the super. The defendant has fled, cut off the ankle monitor. They found it on the MARTA train. Just crazy. And do they know if the ankle monitor was actually working? I mean, I don't know if that would be like flushed out right away. But, we heard, I think it was Shannon Stillwell, that like they couldn't even properly say that he was in a place or not in a certain place using the ankle monitor report because the batteries would just be dead when they weren't supposed to be dead. So maybe he was on MARTA when he wasn't supposed to even be out of the house, and they could have been on alert for that. But they didn't find out until later because maybe that ankle bracelet was just as dysfunctional as some of the other ankle bracelets we heard of. Like, who knows? How can you even have confidence? So, and hold on one second. I just took like the biggest gulp of water in my life. So I've been yelling at my screen too much. Had to get the voice back. Um, but yeah, so Shannon also says, so you went off the Fulton County Victim Witness Office and then poor communication. And then, yep, they're changing the ankle monitor companies. And I just don't understand it. And I don't understand why we can't get ankle monitors working. It seems to me, maybe I'm wrong, but it seems to me like it'd be way more affordable to getting like working ankle monitor, like companies, devices, everything that we need to do to check the boxes the right way, and anything required to do proper monitoring, than putting heads in beds or adding more heads to facilities that are falling apart, like Rice Street. So there's funding to try to reduce the overcrowding at Fulton County prisons. they're still trying to decide what they want to do with the Rice Street building. Are they going to get this funding to fix it, or are they just going to demolish it? And then what are they going to do with all the individuals? Well, a good plan, a good strategy would be ankle monitors are a way that pre-trial we can get someone out of a facility, out of holding. Why don't we put some of this money that's going to a building that might have to be demolished anyway into getting this system up and running? And I just don't understand. I don't understand the strategy. I don't understand the lack of any change. I don't understand how it keeps happening. Um, and unfortunately, it's something that affects you directly, but I'm not surprised to hear the update that you're giving. Like, it just, yeah, they do it to make us laugh. They do it to make us laugh. And one of those, like, how do we keep doing this ways? So that is, I'm sorry that that has not been a positive development in that, again, after all of this time. So, and thank you again for your support. Guys, we didn't really need to look at much. We had the supplement from Cardi B's team just to show that they FedExed, the November 6th, like, hey, we're deeming Janfaza served. Um, that's all that was, the other filing. Maybe I'll refresh one more time, see if anything came in today. Although it's only 1:23 East Coast time, so uh, oh. Well, I don't really want to grab this document. This was not here yesterday. Maybe it was here when we started up the stream. But yesterday I only saw this declaration with we tried to FedEx overnight and the recipient refused delivery. And then the filing that we read today, this opposition to the order to show cause. I didn't see this motion to tax costs. And it's 33 pages. Is it going to give me a CAPTCHA? Maybe there's something interesting on the cover sheet. Muted, sorry. I don't know if there'll be anything interesting on the first preview, but we can at least see who filed the motion. Maybe. Maybe it doesn't want to load. But somebody appears to have filed, you know, they want a motion to recover some types of costs. This would be, this is typically after trial anyway. And the judge would be able to weigh in and say, like, hey, this would be recoverable, this is not. It's probably coming from Cardi B's team, but the reason I want to verify is even though Cardi B was the prevailing party who would be in the position to recover costs, I feel like I need to verify that it's not coming from Emani Ellis. So it's still circling. I'll refresh this. I don't think this is this important, you guys. But if it's something crazy, like it is Iran actually trying to recover costs, I will certainly make a post about it. But yeah, I don't want to pay for a 30-page document. Oh, is it going? I can't believe I'm saying that I just want to verify who filed this. So, oh, okay, it's currently unavailable for preview. This may occur if the document's missing from our system or the document's too large. I think it was recently uploaded, so maybe this will fix itself later on, and I'll just check back on it. Again, it should be from Cardi B's team. But I'm curious, I feel like I need to verify. But yeah, so that's what we've got. We'll get together for more updates on this next week when the defense is expected to reply to Janfaza's Ron's opposition. We'll see how they argue. And then again, right around the corner from that response, December 5th is going to be a hearing in front of the judge. So the contempt hearing and the motion for a new trial. If you missed the motion for a new trial, both the motion itself and then Cardi B's response are linked in the description of this video. We've got a let's get at least one book going. Let me send a book out. You guys want to pick a book? Let's see. And Emily D. Baker, I see as I'm opening my YouTube, is live right now talking about the Karen Reed lawsuit. So let me drop a link to her. If you guys missed that lawsuit, I think it was really well written. Even if you didn't follow Karen Reed, it's still super clear. So EDB in the YouTube chat there, and maybe we'll redirect over there if she allows redirects. But yeah, she's got 14,000 people over there. That's what I'm saying. Like if she, and I feel like she will because she did great coverage. You guys all recommended it about some of the stuff going on with Janfaza. Um, she just got to find the time, I'm sure. But that's the thing. Like maybe he doesn't think people will pay attention to these motions, these ridiculous motions. But I'm small peas and potatoes over here. But if EDB covers that, that could be tens of thousands of people looking at and going like this to the stuff that he's filing. Um, all right, so found my pinned comment, found the wish list. All right, do you guys want to send a book to end the stream with? You guys can vote. We've got Heidi, we've got Harry Potter. Oh God, we've got Winging It, which might be really applicable to what we're reading today. We've got Ferris, we've got The Last Day of Summer, New from Here, finally seen, The Chronicles of Prydain, The Wolves of Willoughby, A Place to Hang the Moon, Frightful Mountain, On the Far Side of the Mountain. And guys, this is every day that we stream, we're gonna pin a wish list from a teacher for classrooms for Christmas gifting. This is Mr. Blackwell and his students, the books that the students are requesting that are on their reading list. So we've got The Year of Miss Agnes. I think we might have to do Winging It. I think Winging It makes sense after what we read today. We've got Harriet the Spy, a classic. Invisible Guest. We've got Drawn Together. The Invention of Hugo Cabret. The Bad Beginning. Jeremy says Dante's Inferno. Oh man. We're gonna get stuck on what floor was like, well, this purgatory before the floors. We might be stuck there. Uh for Emani Ellis, this might be some Sisyphusian. We're just like stuck constantly pushing the boulder up the hill, except it's of their own volition. It's not really something that they're sentenced to do forever. They're choosing to continue to push this boulder uphill. Yeah, I think Winging It might be the one. And we'll continue to check these boxes off. Oh, we've got all the sports ones. We got all the biographies coming in. Milton Hershey, Travis Kelce, Michael Jordan. It's cool. Oh, I remember the Babysitters Club. Goosebumps. It's cool to see like half the stuff is familiar to me and then the other half I'm like I have no idea what it is. So, the classics still are classics and there's some new stuff too that's totally not on my radar. So we'll do a Winging It and I'll throw in what was the other one that was kind of close? Let's do New from Here because he's a new attorney. And I'll grab those. I've got to do that in a separate window, you guys. Otherwise, it like shows every address I've ever mailed anything to. But I'll check out for those two. And I think next stream will also continue with Mr. Blackwell's classroom as the pin the list. We'll keep that one pinned. So there we go. He is a teacher in North Carolina getting books for his kids for his classroom. So those will be sent. There we go. Oh, it might not let me order it then. Uh, it let me order it. I'm gonna cancel mine because it only says one, right? So Trikisha, if you just got that, I'm gonna cancel. I'm gonna edit my order. I'm gonna cancel new from here. I'm gonna add a second one. Can I cancel one? All right, I successfully canceled new from here. I'll swap it out for a different one. We'll do finally seen. Seen, but not in a good way. Uh, let's do, maybe just do a scroll and pick a random one. Oh gosh, Hansel and Gretel, the breadcrumbs. All right, we're just gonna, where am I? All right, we're getting the Night Librarian. That's a new one to me. I don't know what that is. These kids these days. So there we go. Thank you, Trikisha. So we've got that one checked off, and this should be corrected. Push this one through. And we'll wrap it up, you guys. If I can send to Emily, I'll redirect us over there. If not, we can see who else is on. And I'm sure there'll be something crazy we're streaming about between now and next Wednesday. But again, that will be the next time frame for, unless they file early, that'll be the next time frame for an update, a deadline in the Cardi B Emani Ellis saga. And yeah, so I can't redirect to EDB. Can't do it. She doesn't want us. So use the link that I dropped in the chat for that. Um, Dolly has a bunch of, we can do, I think we did Matt Land's coverage yesterday with Take It to Trial, so we can redirect over there. Dolly has an upcoming court roulette stream, but it's not live right now, but just putting that out there. Yeah, I don't think it's refreshed. I don't think I'll come back live, Destined to Be. What I'm gonna do for that is I really just want to see, like the header of the filing, just to verify that it is coming from Cardi B's team. It should be Cardi B's team that's seeking, some type of recovery because they're the prevailing party. So I really just want to try to verify that first page. I don't really want to buy a 30-page document. It gets pricey. LA Court's not too bad. They're not one of the most expensive, but that would still be like a $35 purchase. And I really think we just need the first page. So I probably wouldn't come live for that. I would just post like, hey, this is actually the other party filing for something, even though they did not get a favorable verdict. Like I would post if it was something that I didn't expect to see. And of course, we'll mention it when we get back together for the next live as well. So there's that, you guys. We're going to redirect over to Take It to Trial. So say, hey, tune into that trial if you want to check it out. And hit the notification bell, hit the like. That way, whenever there's something we do go live about, you guys want to come hang out, you'll get a notification. So see you guys next time. Bye, guys.